2016.
No, but this week will be a very difficult week because a lot of interim orders will be coming. Withdrawal, you please make it to first week of January, because we'll not be able to accommodate.
Because the order was passed in.
No, I understand, but last week we are not accommodating this. This will not be in urgent category.
Okay.
So please excuse us for this week. We will not be able to handle these matters along with other interim applications.
Yes.
So
Then I will mention in one date and.
you
first
just
week
give
of
it in the first week. Give it any day you want.
Alright.
Even on the reopening day, we won't mind. Yes,
Need to mention item number 34.
34.
In this case, I am able to respond that I've taken the consent from the appellate. I'm praying for some accommodation. In this case, I'm led by senior counsel, Mr. M.K. Chaudhary. He could not prepare the case properly. So I'm appealing for that.
Okay, both sides are represented. On the prayer made by Mr. S. Chakravarti, counsel for respondent number 1, matter stands adjourned today. There's an interim order. Interim order passed earlier, stands extended till the next date of listing. List on. It goes to first week, January. Third of January?
Any name.
5th?
No.
Okay.
Okay.
Yes. Yes.
I think 6 will not.
Yes.
6 today will not. They taken after vacation.
After?
After that.
After vacation. Okay. Item 6. List after ensuing winter vacation as paid for by Mr. A. Rashid, counsel for the petitioner.
If you consult from the other side, vacancy item number 16, matter will be taken up on 9th of January.
16.
16.
Okay. 9th is what? No, not on Tuesday. Monday or Wednesday or any other day. 8th. Okay. Item number
16.
16. With consent of the other side, Mr. S. Deka, counsel for the private respondents. Praise for adjournment. Prayer is allowed. Any interim order is there?
Yes, Lord.
Interim order passed today, stands extended till the next date of listing. List on 8/1/2024.
Item number 44 of today's list, it may not be reached possibility. My problem is also with a 75 years old lady. So may upgrade or lordship is not difficulty because the motion day is today. So
We'll try to-
any day after vacation, lordship.
We'll try to accommodate, just wait for some time.
Lordship.
In the second half,
Lordship.
see if it can be,
Lordship.
but you ensure that the other side is present.
Lordship. I will inform.
Huh.
Hey, please, you concept from the other side. I pray for applicant matter item number 43. And matter has already been settled before the local order, but as the claimant physically not present before the local order, will not discuss on that day. 43.
43. Your name?
P.
Mr. P. Nyok, counsel for the petitioner, has submitted that the parties have arrived at out of court settlement. But no formal order could be passed in the last Lok Adalat as the petitioner could not be present. So accordingly, matter stands adjourned today.
I pray for upgrade if possible.
Huh?
Pray for upgrade if possible.
Upgrade we are not doing. You wait for a turn. You wait for a turn, then it's not required.
Yes, please. I'm going to mention item number 2, lordship.
Item?
Item number 2. The matter will be fixed at 2 o'clock. 2 o'clock, lordship.
At 2 o'clock.
Yes, sir.
Okay, item 2.
Much appreciated.
Yes.
First appeal on Monday. Some injunction matters. Thursday, let's please be on Thursday.
Pardon me?
Let it be on Thursday, Malak. This is a new case.
Thursday, we are not taking, Wednesday at best. Wednesday. Okay.
May I please, Lordship? I beg to mention item 55, Lordship, of the supplementary list, Lordship, with the consent of the other sides, Lordship. Have some difficulty with the Lordship. It will be after vacation, Lordship. It's a hearing matter.
Okay, you have taken the consent?
Yes, Lordship, they are also here.
Okay. Both sides are represented on the prayer made by Mr. M. Ahmed, counsel for the appellant. List after ensuing winter vacation. This, if this goes, there are series
Yes,
matters.
yes, yes, all the 4.
Item
52 to 55.
Item 52 to 55. Okay.
I have read. I'd like to mention item 10.
10.
Matter may be taken Wednesday. Item 10.
You've informed the other side. Why can you make a, how can you have the courage to make a mention without informing the others? You have absolutely no decency with the members of the bar. You don't expect them to be informed. We'll take up the matter at what you call 4:30 and then adjourn it. Be here, then you will understand what is the meaning of taking an adjournment ex parte. What is this practice? How did you think of it? You wait till even for the mentioning, you wait till 4:30. That will be a punishment to you. Then you will understand the practice of not informing the others and then adjourning it. I'll do the same thing with you. We'll make you wait till 4:30 and then adjourn it. Then you will understand the pain. Otherwise, you will not learn. So it is refused and we'll take it up at 4:30. Absolutely astounding. How could you have the courage of making a mention without informing the other side? Is this a good practice? In the morning at 10:15, do you think it was a good practice? 4:30. And if you're not there, we'll dismiss it. Yes.
MSc agreement. The respondent is suffering from cancer, so I want early hearing.
It goes in January, not in this month.
First week, my God.
Give it. The courtmaster will make adjustments and give it. Give it to the courtmaster, he'll make adjustments and give it.
I beg to mention this NSC field for listing. It's a whole pending matter.
It goes in vacation. The courtmaster will have to make some adjustments
After vacation.
after vacation.
All right.
Yes, item 1. What is the ground? The probate was allowed or rejected?
The probate was allowed. Probate was allowed. What means the
Just a ground to show that why it will not be believable.
The petitioner died. One of the petitioner died. When he died, his legal are not entitled to get the property. At least they can apply for the letter of admission. Moreover, the will that was not produced at the time of procession. The category says that they have got categories.
Okay. But Mr. P. Upadhyay and counsel for the appellant. But this appeal under section 299 of the Succession Act 1925. The appellant has sealed the order dated 29/9/2023, passed by the Honorable District Judge Kamrup Amendo in probate TS number 3 of 2014, by which the probate was allowed in respect of the last will and the last will dated 4/7/2005. Of the testator, namely Mohammad Masiruddin, Maseruddin Sarkar, who died on 19/2/2006. The appeal is admitted for hearing, call for the records. Issue notice returnable in. Give a date of after 6 weeks. Notice returnable and so and so. The appellant shall take steps within 2 days for service of notice on the respondents by registered post with Delhi, as well as by usual process. The counsel for the petitioner is at, appellant is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. You'll have to file what you call interlocutory application for stay.
Yeah.
The appeal will not be permissible. Pardon me?
This says that not required. I have.
Office says it is not required. Okay, till the next returnable date, the operation of the impugned order dated so and so, passed by so and so, shall remain suspended.
Item 3. At least Lordship, in this case, I am challenging a order dated Lordship at 10/8/2023 passed by the learned civil judge Morino Assam Indian Miss April number 20/2021. Lordship, whereby the appellate court is setting aside the order of temporary injunction passed by the learned Munsin number 2 Morino Assam in on the ground that the Lordship with a balance of convenience is not in favor of the plaintiff. Lordship, the Lordship department the plaintiff are the Lordship, and that the Lordship the defendants are trying to dispose me from the suit list, and the Lordship they are trying to
Just a moment. It was with you. It was with you. 24 calendar लो है जो मेरे को 24 का calendar
हाँ ये तो है
मैंने yes
Lordship, the defendants are trying to dispose me from the suit land. Then Lordship, I filed a civil suit for declaration of a right title and the interest.
but you come to the prayer in the plaint. You have also made up, you have not only prayed for confirmation of possession, but you have also said that if they are found in possession. So what is the stand? How have you explained that they are in possession? Sorry, you are still in possession.
Yes, Lordship.
Because the defendants also say that they are in possession.
Yes, Lordship. Lordship, in my planning that the plaintiffs are stated that they are in possession of the suit land, and that defendants also in their planning is that they are in possession of the suit.
Correct.
And the Lordship, the municipal court number 2 decided that 3 important principles in favor of the meet, and the Lordship, the appellate court, while passing the
But if somebody is in possession, injunction can't be granted.
Lordship, I am in possession of the suit and Lordship.
Shows that you are in possession.
Yes.
How have you shown that you are in possession?
Yes, Lordship. My title is Dear Lordship, and
No, title is nobody is disputing the title.
Yes,
The question is that how are you in possession? Because the defendants also claim that they are in possession.
yes, Lordship.
So under that circumstances,
We decided by the court, Lordship, it is a pre-measured instance of the trial, Lordship.
no. You see, by way of an injunction, there can't be an eviction.
Yes, Lordship. Lordship, but the appellate court left the bottom party for fighting the possession of the suit land. Lordship, I am in the possession of the suit land, and then
I understand, but what is the proof? How will you establish?
Starting with the suit and law. land is only for my livelihood lordship. And the counting details and since they of my father lordship. Lordship now defendants are my relatives and they are trying to dispossess me twice lordship. That's why lordship I filed a case suit the lordship. And I filed the injunction petition. And the Munshi number to allow my injunction petition lordship, but the appellate court lordship lordship only ground was that the lordship the defendant stated interpolating that they are in possession of the suit. So there is a purpose finding on.
Which one?
So I am stating that I am in the possession of the student, and the defendant also is stating that they are in the possession of the.
So it is affidavit versus affidavit. How will I come to a finding that you are there in the suit land?
But in the appellate court, decided the balance of convenience.
Yes, prima facie case is in the favor of you,
Yes, Lord.
but the balance of convenience is because of the possession. If somebody else is in possession, because you have made a prayer for eviction, in the event they have dispossessed you.
Yes, Lord. Lordship, I filed this case for lordship at the time of the coronavirus outbreak in India, lordship. At that time, lordship, I could not protect my property if they evict me, lordship. So that's the lordship I put this paragraph.
Let me issue a notice, including notice on the prayer for interim relief, because if you can't show your position.
Lordship, the operation of the impugn order, lordship, maybe it's that lordship.
No. Not at this stage, but we are issuing a notice, including notice on the prayer for interim relief. You see, if there is something from which we can infer that you are in possession, then we would have granted you a stay. Because you have prima facie case in your favor.
Yes, Lord.
It is only the balance of convenience.
Yes.
We'll issue a notice then. You are Mr. Suraj Deori.
Yes, Lord. Yes.
Mr. S. Deori, counsel for Mr. S. Deori, counsel for the petitioner, by filing this revision under section 115 CPC. The petitioner has assailed the appellate order dated 10/8/2023, passed by the learned civil judge within bracket senior division bracket close Morigaon in Miss Appeal number 6 of 2021. Which was an appeal filed under order 43 rule 1R of the Civil Procedural Code against the order of injunction granted by the learned trial court. Issue notice, including notice on the prayer for interim relief, returnable on. Does he give a date? Make it last date only. Previous case, same date. Returnable on so and so. The petitioners shall take steps within 2 days for service of notice on the respondents by registered post with AD. First of the learned counsel for the petitioners is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, by the list and so and so for considering the interim prayer made by the petitioners.
Item 4.
Yes, Mr. Sheikh.
My lord, it is a very short question involved, my lord. What happened,
Yes.
my lord? I'm a plaintiff. I relied on a deed. Deed number is correct, my lord, but
Date is wrong. Okay.
Date is wrong, my
Okay,
lord.
okay.
That is
Heard, Mr. M. A. Sheikh, learned counsel for the petitioners. Next, by this application under Article 227 of the Constitution of India, the petitioners have assailed the order dated 14/9/2023, passed by the learned civil judge within bracket junior division, bracket close number 2, Dhubri, in Ms. J case number 114 of 2023, in TS 137 of 2014, by the impugned order comma, the prayer for amendment of the plaint only to correct the date of the sale deed from 27/2/2012, sorry, 2/2/2012, TO2, 27/2/2012, on the ground that a typographical error had crept in the plaint while writing the date of the sale deed. Next, I should notice returnable on so and so. Steps, same. Postal track report. The next, consider the prayer for interim relief filed as prayed by the learned counsel for the petitioner. So as the as incorrect description of date in respect of the sale deed may prejudice the petitioner in course of trial, comma, the court is inclined to stay the further proceedings of title suit number 137 of 2014, pending for trial before the Court of Learned Civil Judge, with the bracket Junior Division, bracket close, number 2, Dhubri, till the next, till further orders. Okay,
The proceeding is there.
I've stated.
Already.
5.
The list after.
No, I did this way too. I got it same day. 6, 2, 2. Item 5.
This is the case under Assam Urban Areas Rent Control Act.
Yes.
The defendant, the plaintiff.
But how can we entertain the plea at this stage when you are challenging the that he's not the landlord?
That was a
This is a plea which can't be accepted.
This was a consistent plea from the WS itself. Your Lordship.
But in an ejection suit that is prohibited.
Lordship, I am.
Inquiry as to title cannot be taken up in the ejection suit.
Lordship, another view of the material, Lordship. The suit property was constructed by the brother and the sister jointly. And
How do I know that? You see, let me tell you that smallest example. For example, yesterday we purchased a pen, correct? And the price of the pen is 5 rupees. I had two rupees coin in my hand. And when I was, the shop owner did not have change. And therefore, one of my bungalow peon, he was accompanying me. He said, that, sir, I will pay that 1 rupee. And yesterday when this pen was purchased, I contributed 4 rupees and my peon contributed 1 rupee, and we got this pen. Now, is this the intent of me while purchasing this pen, that this would be a joint ownership or a co-ownership of this pencil? So you see, somebody may have contributed for the house. Can you demonstrate from any document that this was a joint property and therefore this was joint holding, or the land was mutated in the name of the sister, or that he had a right? Because otherwise the legal position is that the ownership transfers from the earth. So if anything in the earth, it will belong to the owner, whether who has contributed or not.
the property here, Your Lordship, was an ancestral property. So my stand from the WS from the very inception is I have been paying the rent to the landlady, Your Lordship. That is in the WS.
Where is the proof that the sister had contributed?
Contribution, even if we ignore the part of contribution, Your Lordship, Lordship will peruse the title, judgment of the title suit, Your Lordship. At page.
Did the lady come and depose in favor of
She
you?
was not made a party, and that
No.
trial court.
May not made a party is different thing. But have you called him as a witness and then to depose? So therefore that plea is not proved.
Lordship, the trial court has specifically held that it was the duty when the stand was taken that I have been paying the rent.
That's wrong.
There can be two ways
That would mean the shifting of burden to the third party to prove.
on the plaintiff, Your Lordship, not on the third party.
For your plea, he's a third party. Second party or third party, whatever you call him. You took a plea that my landlord is somebody else. The burden as well as the onus is on you. Once you can establish that the sister was the owner, then the onus will shift on the landlord to establish that no, she was not never.
Lordship, to throw me out of the tenanted premises, Your Lordship. Lordship knows that there are two ways, Your Lordship. The suit premises has to be in bona fide requirement of the landlord, or I have to be a defaulter, Your Lordship. My consistent plea from the WS was that, Your Lordship, I have been paying the rent, up to date rent, to Srimati Ranudas, who has inducted me as a tenant, Your Lordship. I have annexed the tenant.
Suit for compensation. Suit for compensation. If she has received rent and allowed third party to file a suit, you file a suit for compensation, seek damages. But why will the landlord suffer for it?
I have, Lordship, I have annexed the agreements, Your Lordship, copies of the agreement, which I have not executed yet. Admit, Your Lordship. Copies of the agreement.
Where is that?
Is that
The
there are two
section,
agreements, Your Lordship.
because section 49 of the Transfer of Property Act will come in. The no court shall.
The agreement specifically states about the brother also, Your Lordship. Page 63 is the agreement of 2011. Your Lordship.
53.
63.
63. No, but you see, this 49 will come in.
Yes.
No court shall lead in evidence a document which is required to be registered and not compulsory registered.
This is the text copy, Your Lordship. The third paragraph itself speaks about the brother, the husband of the plaintiff. And there is another thing, Your Lordship, in page 71, lecture 7. This is a subsequent development after this.
Page
71. This is a subsequent lecture 7.
yes.
This is a subsequent development after this, before this, just before the judgment, Your Lordship. This is a complaint case under section 145 and 147 CRPC filed by the plaintiff, Moromi Roy, against Reena Das and Ranu Das. Ranu Das I am claiming to be the actual landlord, Your Lordship, for the same property. And here in paragraph 7, Your Lordship, they have stated at page 74 that the first party has inducted me, Golin Gora, and the remaining portion is in lock and key under the position of the first party. To this, there is a written statement filed by Ranu Das, the actual landlord. This, which I have also annexed at page 78. There are 6 at page 82 of the written statement speaks about my position as a tenant.
See, then also you fail. You'll find a decision of this court in what you call India Umbrella Manufacturing Company Limited, or India Umbrella Manufacturing Company. Whether it is limited or not, that I don't know. You see, the facts of that case was that a ejectment suit was filed by one of the co-owners of a land against the tenant. During the pendency of the suit, the tenant purchased a share of the another title holder. That was never in dispute, and therefore the claim the defense put forward before the trial court up to the Supreme Court was that once I have purchased a share which is lawful and I have a right for partition, I also have the title, and therefore I become 50% title holder, and I am also a tenant. Therefore, unevictable right has developed because I am myself I am now the owner. And the bench of Honorable Justice R.C. Lahoti, it's a case from Guwahati, And Honorable, the Supreme Court, by the pen of Justice R.C. Lahoti, he devised a manner to execute that, to honor that agreement, and also the rights of the parties by invoking 142 to do complete justice. And what was done was that your extent of your share, you divided the land 50-50, and that's all. So one part was to be evicted. You see, from that the law laid down was that if here you have taken a defense, in this petition you have said that a house was constructed and my brother empowered me. Correct. So brother empowered you means you're not the sole owner, and therefore the tenancy rights which you are letting out in your own name, but the right of the real owner of the land is never extinguished, and therefore the right for eviction will still remain
But Your
from
Lordship,
the suit property, even if you are not a tenant. Let us assume that you are not a tenant. Then also your right to be evicted will remain with the original landlord.
but that right to be evicted will have to be out of two consequences, Your Lordship. Either I will have to be a default in payment of rent, because the paragraph I have shown you, Lordship, just now, it specifically states that I have been paying the rent till date to Ranudas. If I have been paying the rent, there's no question of me being a defaulter, Your Lordship. If I am not a defaulter and the suit property is also not,
No, there's something else. There's something else. You see, when it comes to the appellate jurisdiction, then the court has the power to take into consideration subsequent development by virtue of Order 41/27. Now, in a revision, it says that the court must be bound by the pleadings which are already on record. That is first part. Second part is, insofar as the decision of the this court as well as the Supreme Court of India is concerned, they say that subsequent factor which can be taken account for is the two facets. Number one, defaulter during the currency of the tenancy, and number two, that bona fide requirement. There also there is a judgment which says that by this court as well as Supreme Court, which says that the bona fide requirement must the current trend is that once that bona fide requirement is established on that day, the subsequent development will not wipe off that
bona fide
Because-
requirement was not held in this case, only on the ground of.
on the ground of defaulter.
There was no issue as regards to bona fide requirement. The issues, Your Lordship, will find in the page 31, the judgment, Your Lordship. Part of the judgment. Then there was no issue as to the ownership.
Still, everything said and done. This court in a revision, in a Urban Area Rent Control Act, cannot assume jurisdiction to enter into and decide the question of title. So that part of the finding, it can't be disturbed in a revision, because title of the landlord can't be gone into.
That was gone into by the Munship, Your Lordship, Landed Munship. Landed Munship has held that since the plaintiff could not prove that she had been the landlord and actually receiving the rent from the.
That could not have been gone into. And that also in absence. Somebody in absentia is declared as a landlord by a court where the assumed landlord is not even a party.
Lordship, here the Landed Munship, if I may read, Your Lordship.
Yes. Page 32.
34.
34. Yes.
Landed Munship was deciding on the issues together, Your Lordship. If I may read from the last.
Yes.
Fifth line, Your Lordship. From the last paragraph, Your Lordship. From the house rent agreement, it appears that Runu Das was empowered to collect house rent in absence of Tilakram Das. Though the defendant did not adduce any evidence from his written statement, it appeared that he paid the house rent not to the plaintiff but to Srimati Runu Das, who inducted as landlady of the said suit premises regularly. The plaintiff.
Mr. Mukherjee, you can't sustain this judgment. It is absolutely illegal. It could not have been done. You see, the defendant does not come to the dock, does not give evidence, and the trial court finds from the written statement that is proved. The plea that the landlord is someone else is proved only because of the pleadings and documents. The document is that agreement. That agreement could not have been looked into as it is not registered. Creates a tenancy more than a year. It could not have been gone into. So that what you call this, this judgment is not even sustainable.
But here in this case, Your Lordship, what actually happening is, Your Lordship, the landlady who is actually receiving the rent from me is not a party to the suit. And this lady, the sister-in-law, Your Lordship, she has filed the suit against me and is trying to evict me so that she can get the possession of the suit. And there is an internal dispute that Your Lordship has observed from the petition that has been filed under CRPC, Your Lordship, between the.
You would tell me the law if you can convince me that the title can be gone into at this stage. You have made out a case. Otherwise, this has to be dismissed.
If I look for some judgments in that regard from the Supreme
Pick it up day after tomorrow then.
Court.
List on
Even if immediately after that it means.
list on 3/1/2024 as prayed for by Mr. B.J. Mukherjee, counsel for the petitioner. Seven. Yes, how many adjournments you took?
For 3 years, John, because the person stays in Calcutta. He
Only-
stays in Calcutta and he's the agent man. You also will find even the present affidavit is also done from Calcutta. But then the
Okay.
delay is of 196 days, 96. And it was already filed, and my lord, your lordship may look into last page, page 73.
373
On Annexure 7, page 73.
or 73, okay.
On 22.
Okay. Heard Mr. P.K. Roy Choudhury, counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 7/6/2022 and 15/12/2022 passed by the learned civil judge within bracket senior division, bracket clause number 3, Kamrup Metro Guwahati in TS number 141 of 2021, posted by the said order. The opportunity of the petitioner defendant to file written statement was foreclosed, and the written statement which was filed on which date? Which date you have filed that written statement?
My lord, I find the written statement on 26/9/22.
On 26/9/2022,
9/22. Page 72, your lordship will find.
was not accepted. Next para. Issue notice, instructed within 2 days, notice is made returnable on same day. The postal receipt, postal track report. Next, for the learned counsel for the petitioner has prayed for interim relief of staying the suit proceedings. First of suit proceeding by submitting that the petitioner defendant is a resident of Calcutta, and there was some delay in communicating and filing of the written statement. First off, having noted that subsequently the defendant, the petitioner defendant filed a written statement, the court is inclined to stay the further proceedings of TS number 141 of 2021, pending in the Court of Learned, Civil Judge, Senior Division, bracket close, number 3, Kamrup Metro Guwahati, till further orders. Eight,
Item 10 will open that form to be as for category to say it will nothing else. And if you remember it,
yes, Mr. Roy.
So the petitioner, so the defendants, they filed two petitions before the council. One for producing secondary evidence, the dominant photocopy, the other one is for direction for conducting. By the order passed, virtually, the defendant has been, the filing document today, has been proposed for once for all. In fact,
No,
what
but you
happened-
see, the steps are required to be taken at an earlier point of time. You allow the plaintiff's evidence to be closed. Then you file this application.
No, my lord, I filed it because I have stated in my plea, I have stated the plain plea. I cannot file because it is established after the defendant has, evidence is over. The defendants, in fact, in his clause also said, the point number 1, which I filed in a statement, is the original of which is exhibit A. The same thing he has admitted. Now, after that only, I have filed because this document is my main document. The existence or non-existence of a fact in issue has to be proved under section 5. The non-existence of that part, this is a fact matter. I must prove my own case. That's the situation came along. Therefore, I said I must be allowed to exhibit the photocopy. This is not.
But you see that, you see, after closure, these issues are required to be taken during the stage of steps before plaintiff hearing. The steps having been taken at a later point of time, prejudice will be caused to the plaintiff.
No, my lord, it is how will you prejudice, my lord, if I may submit.
No, I don't know. That is the procedure because subsequently in your evidence stage, you can't be permitted to adduce document evidence.
I have the same document I am asking. Yeah, I have annexed along with my written statement, the photocopy. I
No,
have
but look at the procedure. It says that the steps are required to be taken during steps before plaintiff hearing. All steps are required to be taken then.
This is the stage for exhibiting documents, defendant's document.
No, you see, the stage is at the SBPA stage. The court may issue, may postpone the issues of process. But but there are two things. Number one, this is one, and then
When the stage is
just a moment. I'll show you something.
list of documents, I have annexed to it. The photocopy I have annexed. That is there, he has not raised anything. Along with my list of documents, I have annexed the photocopy. What I am required to do is to prove my photocopy. Not too late, my lord. To secure the ends of justice, my lord, the court ought to have, I am not, my lord, saying so much about the, calling for handwriting expert, my lord. It's not that it can be looked into at later stage. My document has to be allowed to be exhibited, that's why. That's my main case. My main case is, in the original, he has changed because it was kept blank at the time of entering into the evidence. those, my lord, the description of the land and the names of the witnesses, the boundaries all were kept blank in the original. So subsequently, what he did, my lord, original was within, he put it in the filled up the blank part and, my lord, filed the suit. I said, this is the original photo, when the deed was executed, photocopy was given to me. In my defense also, I have said. And when I found the plates, my lord, I found that these are filled up. That's why I said that I must prove my facts in issue, my lord, existence, non-existence, that must be proved. That's my only case. Maybe, my lord, there's some, even at the beginning, I should have said that, but this is not too late, my lord. He can very well cross-examine me, he can very well look into it. And it is not that I have not pleaded, there is a pleading. In so many words, that this is a photocopy and the original you have changed it. He has the notice of it.
You see, I'll just show you this. Civil Code rules and orders, as well as this, the rules. Just a moment, I'll show you something more.
So 13, 14 years he filed the suit.
Hmm?
After or 15 years he filed the suit.
I put two flags. Same, first flag, the second flag is a reiteration of the first flag. Dashi. Dashi. You know this very well. I need not show it to you, but still, just for your satisfaction, this is discovery and inspection. Here, where your hand is there, that the rule says that everything has to be done prior to the settlement of issues and before evidence.
But in my WS I have stated that it is in my WS I have stated that it is with the originally with the plaintiff. I have not, maybe not, I have in my WS I have specifically stated the original is with him.
The plaintiff did not prove the original.
Did not. That's why he changed it. The one which was original is not true. He has changed it and manipulated it. He added something which was not there.
Show me the evidence part where this has happened.
Well, not evidence, well, not plaintiff's evidence.
Huh?
No, only he said, I have shown him in cross that this, see the document number 1 that I have annexed to the written statement. Is it the same document? Annexure A, the exhibit A, they will say he's saying, he said it is the same. So apparently these are two different.
Sure, shows that.
Page number 103.
103.
The third one, document number 1 is my WS document number 1. Copy of original plaintiff file for exhibit A. So, but these two documents, if it's shown, exhibit A, all things are filled up. Document number 1, but non-existence, unfilled.
Okay. Heard Mr. T.K. Roy, counsel for the senior counsel, assisted by Ms. A. Chakravarti, counsel for the petitioners. Oh, sorry, Mrs. M. Datta, counsel for the petitioners. Next para. by filing this application under Article 227 of the Constitution of India, the petitioners have assailed the order dated 13/10/2023, passed by the learned civil judge within bracket senior division, bracket close number 2, Kamrup Metro, Guwahati, in TS number 290 of 2018, by which the petition filed by the petitioners dash defendants to call for the original of document A,
Secondary evidence. to allow
of
secondary-
document A,
No, my lord, it is document number 1.
document number, the defendant's document number 1, and to lead secondary evidence was rejected. The learned senior counsel for the petitioners has submitted that the original of of document number 1, of defendant document number 1 is lying with the respondents, respondent plaintiff. Which was blank in some places, which was subsequently filled up. And therefore, the application for production of original and to lead secondary evidence was filed. Explanation notice returnable on so and so. Steps within 2 days. Postal receipt number, track report. Next, till the till further notice for the proceedings of title suit number 290 of 2018, pending before the Court of Learned Civil Judge within bracket senior division, bracket close number 2, Kamrup Metro, Guwahati. It's number 2. Suit is pending before which court? 2. Kamrup Metro, Guwahati shall remain stayed.
Second one also, my lord, the last time we issue notice on the second one only. The second petition.
Same suit.
Same.
Okay, here only notice, no stay is required.
Deep level.
Item 11. Yes, Mr. Das.
My lord, actually, my lord, one agreement was there, my lord. Before the notary, there was the title suit was, my lord, degree. And in the degree, my lord, there was two, my lord, order was passed, my lord.
But why should we entertain this revision? You see, this suit was decreed when? What is the date of decree?
My lord, 21 to 2019, my lord. Annex
19. Okay, just a moment.
Annex, sir.
Just a moment. Let's come to this form of execution. This in the CPC, you'll find at the end, Appendix E, form number 6 is the form of execution. Appendix E.
Yes, appendix C.
Yes. You come to column number 6. Previous application, if any, with date and result. So therefore, you see in an execution case, there is nothing called dismiss for default and it's permanent. You can file as many as within 12 years. You can file as many as applications and allow as many as applications to be dismissed for default.
But here, my lord, in this case, my lord, in the decree order, my lord, there was two portions, my lord, here. One, and the first portion, it was in favor of the opposite party plaintiff, my lord. And in the second portion, it was, my lord, to back that amount, return the amount, 3 lakhs, my lord. We have already submitted, my lord, application, but that has been rejected. That petition also rejected, because nowadays it is, my lord, 23. It was of the year 2011. And admittedly, they were absent in the date, my lord. And that's why, my lord, on 3 dates, as they did not appear, my lord, before the learned court below, it was dismissed for default, page 75, my lord. Degree holder is absent. Without steps fixed so and so for necessary order, degree holder is absent. Thereafter, judgment author is represented, degree holder is absent without step today for the 3rd time consecutively in a row. As such, the instant title execution case stands dismissed and disposed of accordingly.
Correct.
Yes.
But if they have, if the court has allowed restoration,
That's it.
the point is that otherwise also he could have filed a new one. He could not have resisted it. So why, when it is restored, what prejudice do you suffer?
Because, my lord, my application was also rejected, my lord.
Yeah,
Your
that rejection is not under challenge.
Order 21, order 21.
No, that rejection order is not under challenge. Now you are challenging the order of the execution petition being restored.
Yes, no, that is, and then 312/22 also, my lord.
3/12/22,
Annexure 7, page 72.
page 72.
70.
It shows your petition. Where is that petition? Well, this is I am not being able to follow.
Yes, my lord, my petition is, my lord, type copy is page 66,
66.
Annexure 6.
Where is the judgment and decree?
Judgment and decree, my lord, I have annexed here, my lord. That is page starts from, my lord. Annexure 5, page 47, my lord. The judgment and the order portion is below, my lord. Page 58. sale permission cannot be, my lord, because it's a tribal bill. That's, I mean,
That's just,
this belongs to that category. Earlier, she did not hold it.
Mr. H. Das, learned counsel for the petitioner. Next, by this application under Article 227 of the Constitution of India, the petitioner, who is the judgment debtor, in PS number what is the suit number?
29/2019.
29 of 2019
Pending.
has assailed the pending in the court of which was decreed by the learned civil judge within bracket senior division bracket close number 3 Kamrup Metro Guwahati, has prayed for setting aside the order dated 3/12/2022 as well as order dated 9/1/2023 passed by the learned civil judge, passed by the said learned court by rejecting petition number 443/2020 filed by the petitioner and allowing of restoration application of the proceedings of title execution case number 29 of 2019. No, there is something wrong. What is the suit number?
Title execution case number.
No, suit.
Yes, the case number, my lord, 338/13.
It is 338 of 2013. Next paragraph. Insofar as the challenge to the order dated 9/1/2023 where is that 9/1/2023? Oh, not 9/1. Type of 9/1, it should be 5/10/2023 instead of 9/1/2023. Next, insofar as the challenge to the order dated 5/10/2023 passed by the learned where is that?
Order, my lord, page 93.
5/10/93 passed by the learned civil judge within bracket senior division bracket close number 3 Kamrup Metro Guwahati in title in Niche case number 328 of 2023 in title execution case number 29 of 2019 is concerned. it is observed that the execution petition filed by the respondent within bracket judge, decree holder were dismissed for non-prosecution by order dated 9/1/2023. Full stop. Restoration application was filed, which was accompanied by an application under Section 5 of the Limitation Act for condoning of the delay in filing a restoration application. Accordingly, by the impugn order, the delay in filing of the restoration application was a delay of 30 days beyond the period of limitation in filing of the restoration application was condoned. What is the number of the restoration application?
Restoration application is, my lord, page 76,
70?
6, annexure 9. Order 21, rule 106 of CPC. Provision is there, they have quoted. They are also limitation is there in one order 21, 106. 30 days.
Next paragraph. In respect to the said challenge, the court finds that there is no bar in the civil procedure code for filing of a subsequent execution petition after the first is dismissed for non-prosecution. Full stop. Therefore, not therefore, moreover, in clause F of subrule 2 of rule 11 of order 21 CPC, contains provision for declaring before the executing court the description of the previous applications for execution of decree and other particulars as provided therein. Therefore, when apparently there is no bar for a second execution application being filed within the period of limitation prescribed for executing a decree, the court finds that the court is constrained to hold that the petitioner has not suffered any prejudice on the condemnation application being miss J case number 328 of 2023 being allowed by the impugn order dated 5/10/2023. So under such circumstances, the court is not inclined to accept the challenge in respect of the said impugn order dated 5/10/2023. And accordingly, in respect of the said impugn order, the challenge is rejected. Next para. Insofar as the challenge to the impugn order dated what was that order? Page
Page 72, annexes.
72. Order dated 3/12/2022 is concerned, the learned counsel for the petitioner has referred to the type copy of petition number 433 of 2020 within bracket annexure 6 to predict that the decree passed by the learned trial court was for specific performance of contract by the agreement for sale dated 23/6/2011 and alternative decree was to permit realization of an amount of rupees 3 lakh paid by the respondent plaintiff to the appellant defendant, by petitioner defendant as advance for the suit land with 12% interest per annum. And in the said petition number 433 of 2020, the petitioner has made a specific statement that he is ready to pay the money to the decree holder. Therefore, on rejection of the said petition number 433 of 2020 by the impugn order dated 3/12/2022, it appears that the petitioner has been able to make out a case for issuance of notice with regard to the said impugn order. Accordingly, that a notice only in respect of challenge to the order dated 3/12/2022 passed by the learned civil judge within bracket senior division bracket close number 3 Kamrup Metro Guwahati in title execution case number 29 of 2019 is issued returnable on 2/2/2024. The petitioner shall take steps in 2 days. Postal receipt track report. Next paragraph. Pending. Next paragraph. While observing that the pendency of this application shall not be a bar for the learned civil judge within bracket senior division bracket number 3 Kamrup Metro Guwahati to proceed with the adjudication of Ms. J case number. Where is that application? Restoration application, where is that? Page?
Page, my lord, that is, page 76. and
76, huh? BJ case number 327 of 2023 is concerned, arising out of title execution case number 29 of 2019. They said the executive court shall take note of the fact that insofar as the order dated 3/12/2022 is concerned, which was passed in the execution proceedings, if said challenge notice in respect of this challenge has been issued, and therefore in the event the execution petition is restored, the further proceedings of the execution case within bracket presently dismissed, bracket closed, shall be subject to further orders that may be passed in this revision petition. In fact, everything is wrong. The
11.
entire the entire order I have dictated is wrong. I have to recall that order. You see why? When I was writing the last line, I realized that I was doing wrong thing. You see, the execution petition is restored.
Not
and
restored
therefore-
till now. Till date.
Is not restored. That's what I'm saying. So therefore, that order can't be put to challenge in a disposal of petition because it is not live. So I'll have to close this application by giving you liberty that as and when the by restoration, whenever the execution petition is restored, you will have a right to approach the court again.
Unless my prayer petition is.
No, that's
Because
okay.
that
But today it's dismissed. So that is the challenge is rejected. Perhaps insofar as the challenge to so and so is concerned, 3/12/2022 is concerned, the court is of the considered opinion that the issue relating to challenge to order dated 3/12/2022 is not live, inasmuch as the execution petition has been dismissed and the learned executing court is now required to take up and adjudicate the proceedings of Ms. J case number 527 of 2023. Full stop. Therefore, in the event the execution proceedings are restored and the and in the event the petitioner is still advised to challenge the order dated 9/1/2023, the petitioner would have liberty to approach the court again, if so advised. You followed it?
Yes, sir.
If that is your
Yes.
challenge, because now it is dismissed.
Yes, my lord. And petition, if my petition is allowed there, then purpose will serve.
You take a call.
2012 also, prior to filing this title should we serve notice, I have next year.
It's okay. If you are aggrieved, you can be given you liberty to come
Yes, sir.
again.
That will be helpful.
Okay. Item 12.
Well.
Plain was amended, I am defendant, my lord. And earlier written statement filed, and after amendment petition, I filed the additional written statement counter claim. But the in typographical error, my lord. In place of additional, my lord, written statement counterclaim file, my lord. That is why my,
Where is that?
your honor, my lord,
No, the petition. Where is that? Where is your written statement, additional written statement? Where is that?
there are 66, my lord.
Hmm?
There are 66, my lord. Okay, case 66. Yes, amended plan, my lord.
No, no, where is your written statement? You said that there's a mistake. Where is that?
Eighty-five, annexure G, my lord.
85.
Statement, my lord. 85 case, annexure G, my lord. Written statement come counterclaim against of defense number against the amendment plain of the plaintiff's matter. Earlier, I filed the written statement come counterclaim. But in this same, my lord, but the additional of the word is not written. That is why the learned court will think that this is a new written statement come.
Just a moment. Where is the unamended plaint?
Amended. Amended plan.
No, unamended plaint.
Unamended. Page 15, my lord.
16,
15.
15.
annexure A.
huh.
Yes, 15 annexure A.
But Mr. Udas,
Yes, sir.
as Saikia, I'm sorry, Mr. S. Saikia, counsel for the petitioner. Next, we have by filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 18/7/2023, passed by the learned civil judge within bracket senior division, bracket close number 3, Kamru Metro, Guwahati. So by the said order, the additional written statement cum counterclaim of the petitioner was not accepted after amended plaint was filed. The learned counsel for the petitioner has submitted that that in the original written statement that along with the original written statement against the unamended plaint, the petitioner had also filed a counterclaim and the same prayers were reiterated in the written statement cum counterclaim filed against the amended plaint. However, due to first of it is submitted that however, due to inadvertence, along with the in the cost title to this written statement come counterclaim, comma, the petitioner had inadvertently omitted to use the word additional written statement, inverted commas, additional written statement. Accordingly, the learned trial, accordingly it is submitted that the learned trial court construed the written statement. The subsequent written statement and counterclaim as a fresh counterclaim, and the same was rejected. Explanation notice returnable on so and so. Steps into this. Postal District Act report. Next paragraph. Having regard to the fact that appearing the counterclaim of the petitioner is similar to the counterclaim preferred against the unamended plaint, comma, the court is inclined to stay the further proceedings of title suit number 237 of 2022, pending before the court of learned civil judge, bracket goes senior division, bracket goes number 3, Kamru Metro Guwahati, till further orders. Okay.
List from to diminish. এটা opposite.
Yes, item 10, who is there? Yes.
Mentioned for adjournment on Wednesday.
Next time, don't do that mistake, at least in this bench. Don't do that mistake.
We do not have the number.
You should find it out, because you see, if you have given it to him, you can find it out. There's in the High Court library, you will find a what you call the lawyer's directory. So that can't be acceptable. You don't know it. This would you see, if you don't know it, has somebody has the God written a destiny that you should make a mention without knowing, without informing the other side? If you can show that in my horoscope this destiny is written, you'll accept it.
Sorry.
You see, if that is not there in your horoscope, that you have an unfettered right to take adjournment in the absence of others, don't make that statement. You should have, just like now, you should have waited for your turn and then made a mention. Because every member of the bar expects a respect from the other side. Otherwise, we'll not be able to function. We'll have distrust on all the lawyers making a mention. I incidentally asked, have you taken consent? Why should that question be asked by me? You should have told us first that I couldn't take a, what you call, consent. This is unexpected. And I take an exception to this practice. Okay. Both sides are duly represented on the prayer made by the counsel for the petitioner. The matter stands adjourned today. List on Wednesday. Okay. Just tell me, what is the challenge here?
Your Lordship, right to file written statement has been closed by the debt recovery tribunal under section 19(5) of the recovery of debts.
Okay.
That has been.
Okay. Item 13. Yes.
Taking passed by that code below. Continuing the maintenance amount with your favors was passed under section 13 of the intermarriage. So my lord, at this stage, I feel that no one will go to the respondent so that they can come and.
No, are you correct? Are you sure about the nature of challenge? I've not been able to follow. You are Ganesh Das. Ganesh Das filed a title suit for divorce,
Yes,
and that divorce was allowed. And against that order, you have come in appeal.
so she partly agreed with the contribution of the maintenance amount.
Maintenance of 3,000 rupees, you are challenging that. No, we'll dismiss that challenge. We'll accept it. You shows the evidence. But 3,000 rupees. Yes.
Your Worship, in this case, I have filed this appeal against the rejection of my injunction application.
Where is that order?
What's the order is,
You are the plaintiff for the defendant?
I am for the plaintiff.
You are the plaintiff.
Page 176.
176.
Let's start with 175.
Just a moment. Yes.
176. Your Worship, the finding may be the finding of the learned trial court. That which Your Worship. Your Worship, page 86. 186. 182. Your Worship. Finding.
Heard. Mr. Anand Jal and counsel for the appellant. Next, by this appeal under order 43 rule 1 R CPC, the appellant has assailed the order dated 16/8/2023 passed by the learned civil judge within bracket senior division bracket close Morigaon in Miss J case number 49 of 2022 in TS 42 of 2022, thereby rejecting the prayer for ad interim injunction. Next paragraph. You should notice, including notice in the prayer for interim relief returnable on so and so. Steps within 2 days. Postal December track report. Next para as The learned counsel for the petitioner has submitted that all the relevant all the relevant pleadings and documents have been annexed, comma, the the calling for the records is dispensed with for the time being. Okay, so interim prayer, no, it is only notice in the appeal, not interim prayer. For Mr. Anand Jat and counsel for the applicant. It is Miss case. Applicant. Next. By this application under Order 39, Rule 1 and 2 CPC, the applicant has paid for identity injunction to restrain the opposite parties from restrain the opposite parties, their main agents, etc., from selling and then selling, encumbering, alienating, or giving possession of the suit land to any other person. Next paragraph. It is observed that the prayer in the plaint is for specific performance of contract for sale of the land prescribed in the schedule of this application. And moreover, next is observed that the learned trial court had refused injunction, had rejected the prayer for injunction merely on the ground that an alternative prayer for recovery of money was prayed. Stop. Next paragraph. In view of the fact that the petitioner claims that there was a sale agreement for sale in respect of the land, which is dated 5/4/2021. The court finds that the balance of convenience is in favor of the applicant. Stop. In respect of the principles of balance of convenience, the court is of the considered opinion that merely because an alternative remedy is prayed, it would not come in the way of the trial court to pass a decree for specific performance of contract, and therefore the balance of convenience is also found in favor of the applicant. Therefore, if the opposite parties are not restrained from alienating the suit land, there could be multiplicity of proceedings. The court is inclined to ad interim injunction to restrain the opposite parties from alienating the suit land in any manner whatsoever, or in alienating and or creating any third party rights in any manner whatsoever till the next returnable date. Next, I issue notice to the opposite parties to show cause as to why the ad interim injunction granted by this order shall not be made absolute till the during the pendency of this appeal. Next, the applicant shall take steps within 2 days for service of notice, postal registry number, track report, List one, so and so. Granted in action. But take steps,
Your Lordship.
take a break and come back.
Record under section 47, Lordship, under the Guardianship Act, which the petitioner, the appellant herein has father has filed an application to the custody of his minor daughter was rejected. The minor child. And receiving that particular.
Okay, and you'll notice. And it's SP Chaudhary, counsel for the appellant. Next, please. The judgment and order dated 15/9/2023 passed by the learned additional district judge Karimganj in Miss within bracket guardianship bracket close case number 4 of 2023 is assailed under section 47 of the
2021, it was wrongly mentioned.
4 of 2021.
21.
Okay,
Page
has been assailed in this appeal filed under section 47 of the Guardians and Wards Act 1890. The appeal is admitted for comma thereby rejecting the prayer for custody of the minor daughter. The custody and guardianship and custody of the minor daughter. Appeal is admitted for hearing, call for the records. Issue notice returnable in on so and so. Steps within 2 days. Postal receipt number, track report. List on so and so.
Allowed to make necessary corrections.
Correct. Corrections.
Here, 21.
Okay, do it.
And in 17.
Who's there? B.R. Das. I don't find anything wrong in the order. If they withdraw it,
Right.
then the limitation will be lost. Yes. You see, your challenge, I don't find any reason to this challenge. You see, your MSCT case of 2018, you want to withdraw it.
Liberty to file a fresh report.
That can't be granted by barred by limitation, it would be. If some limitation is prescribed for MSCT case,
But
what is the limitation?
This came in 2022, 6 months time. Right?
Huh?
That came in 2022. This case was filed earlier. 163
Huh.
663. 6 months, Miller. But that became effective 1/4 in the month in the year 2022. This is a case of 2015, my lord. This NSE case.
No, no, you see, today when we are ordering it, we will look at the limitation when the case is presented.
Right.
Let us say the new case is presented today. I am the MSCT judge.
My lord,
What will I say?
of course, but that new, my lord, the 66.
I'll see the period of remission prescribed today as applicable today. I don't know, be better advised. There are a few lawyers in the back row I've seen. You may take an advice, because you see, you can ask for transfer of the case from one place to another, but your application for withdrawal, because then we'll say we'll allow it, no problem with that. But then we'll say that at your risk and cost, it will be at your risk. Take a call. Come back at 2 o'clock. Think over till 2 o'clock. Mr. Datta, please come at 2. 18.
Another management takes, my lord, can be some accommodation.
Okay. 18.
I want to give the compensation, quantum of. Order for 13 lakhs.
You can deposit 50%. Okay, MSc appeal, Mr. R. Goswami. Notice and in the stay application, so stay subject to deposit of 50% of the awarded amount within a period of 6 weeks from notice there also. I've allowed 50% within 6 weeks. $19. Only quantum, 50% you can deposit. This DD Burman for the appellant, stay subject to deposit of 50%. Give that condition if without on failure, there shall not be a bar. We'll find out. No. Notice. Notice you just collect the data after some time. Steps within 2 days. Yes, Mr. Chakravarti.
This is for enhancement of
Enhancement. Okay. Mr. B. Chakravarti for the appellants. Bill for enhancement. Notice steps within 2 days. 21.
21.
On these notices, give a fixed date, huh? Not an I. None appears on call for the appellant for enhancement. Notice, steps within 2 days. $22.
there is tenancy. There is no loss of earning. This was a government, Assam government.
You say there is no loss of earning.
Yeah, another head of future prospect and the loss of estate.
Why?
Because as per the Assam notification, he was doing full salary till the date of retirement. Okay, kindly see the notification with it. Which I have next in that page number 46.
Hmm?
Page number 46. Scheme for completion litigation, so you have completion.
Page number
Page number 46.
46.
Was 5.3 also. Page number 47. with the employee by with superannuation dependent pension equal to 100% of the last pay given by the deceased employee. We take for it up to the date of the deemed superannuation of the deceased employee. That is the date which the employee in the superannuation having been alive. This would compensate the loss of family income to a large extent and could be the requirement of compensation concept during the date of starting of the.
Is there any decision of this court on that point? Which one? Okay. Heard.
20% of the order amount.
Okay, heard Mr. K.K. Bhattot and counsel for the appellant. MEC appeal. Admit call for the records, steps within 2 days. Return of on so. Stay application. Here also notice. Next para the learned counsel for the applicant has submitted that the deceased was a government servant and would otherwise be entitled and therefore his dependents would be entitled to receive full salary of the deceased. It is date of superannuation under the notification number FEG full stop 28/2017/26 dated 14/9/2017, by which scheme for compassionate family pension in lieu of compassionate appointment. In short, compassionate family pension within bracket CPF scheme was notified. First, it is submitted that the payment of compensation would give double benefit to the respondents, dash claimants. First off, in view of our work, what is intent to stay the enforcement of the award dated so and so in passed by the land member MSCT number 2, Kampru Metro Guwahati, in MSC case number 612 of 2019, subject to deposit of 20% of the awarded amount before the registry of the court. Within a period of 6 weeks from today. Next point, it is made clear that if such deposit is not made, this order shall not be a bar for the enforcement of the award. List on so and so. I'm returning with this. For deposit within 6 weeks. It's 23. Same. Same, Mr. K. Vato. 24. None appears, and for enhancement notice, starts within 2 days. List on so and so. 25.
Similar
Compassionate. Okay.
also been followed by.
Okay. Mr. R. Goswami, counsel for the appellant. Same compassionate scheme. Stay subject to deposit 20%. Okay. Yes, 26.
26.
Time being. You will tell her how much time? No, you tell her how much time. She's a busy lawyer. I am not. Half an hour. Then make it 2 o'clock because half an hour we want to have time, 2 minutes time for admitting an appeal. Correct. At 2.
My lord, I'm there.
You're there. Just like old Hindi movies. when the,
Like demon running from
when
another.
the person comes to the court just on time. Okay.
Made page of it's the evidence of the defendant. Sort of.
Just a moment, give me 2 minutes. Yes,
The evidence of the defendant's lordship. Suit was filed by 3 plaintiffs lordship. Plaintiff number 1 is the son of late Ismail Ali and plaintiff number 2 is the wife of late Ismail Ali.
no, these things will come later. Just on the substantial question of law, just tell us, how do you propose to sustain those
Okay,
questions
I
of law?
That this is a suit filed by 3 plaintiffs lordship in respect of 4 schedules. Plaintiff 2 purchased 2 schedules and predecessor of plaintiff number 1 and 2 purchased 1 schedule. And predecessor of plaintiff 2 and 3 purchased 1 schedule. There are 4 schedules. lordship.
Schedule land.
Yes. So they have clubbed all the schedules in one suit, 3 plaintiffs lordship in one suit and recovery of schedule B land in favor of the
No, because you see that would not appeal to us because of the fact that if there's a issue of misgenre of cause of actions, then it should have been dealt with at the earlier stage.
Yes, lordship.
Uh,
That objection was not raised by the defendants. In fact, they have raised only non-gender issue lordship. And both the courts held that the non-gender issue, even if the defendants raised, they have not specifically named the persons whom to be joined as parties lordship. So on that ground, that is a substantial question of law I have formulated. That is lordship on the non-gender word is missing for misgender and non-gender of parties in substantial question number 2. lordship.
That cannot be a substantial question of law unless you can convince us, because non-gender and misgender, you'll have to show how prejudice is caused to you. If in the trial court you have not been able to convince the court at the second appellate stage on to upset a decree on non-gender. Because if it is non-gender, you should be very, very happy.
No, lordship, in fact, the vendors of the plaintiffs are the co-sharer of the defendants, lordship. We are the co-sharers along with the vendors, lordship.
Okay.
So there was some amicable settlement in between all the co-sharers, lordship. So unless until all the co-sharers are not before the court, your lordship, the case cannot be projected properly, your lordship. And because lordship, they have claiming some of the suit lands purchased from other co-sharers. And we are saying, lordship, after amicable partition, we are residing over those lands, lordship. In fact, that number 243, 242, all these, that's where after settlement was allotted to the predecessor of the defendants. lordship. So non-gender issue is vital in this case, lordship.
You see, please tell us, assuming that your statement is correct, that you have a what do you call interest with the vendors of the plaintiff. Now tell us, under the Mohammedan law, a right of a sharer to a property
Lordship.
would still have a right to maintain a suit for partition.
Yes,
Now, in this case, I don't find that you have filed a counterclaim with regard to assignment of your specific shares. So therefore, you see, in the plaint, it's only a privacy, what do you call, questions I'm making, preliminary questions to understand. Now see, in the plaint, 4 schedules are given. And you don't dispute that, the correctness of that by filing a counterclaim saying that no, your right accrued in respect of land, X land, and the plaintiffs has a non-determinative shares in respect of whatever he has purchased. That is one part. Second part is that with the statement you have made, I was not aware of this statement, but primary reading of the this judgment impugned of the first appellate court. I don't find that there is a specific evidence led by the defendant with regard to the boundaries of the respective lands which they claim to be under their share, or it is an undetermined share. I don't know. Determined share or undetermined share, I couldn't find out. And I was not aware of this what would come from you, therefore I have not read it completely.
Evidences, Lordship, though I have not annexed with the appeal memo, Lordship.
No, in the judgment it will be written, DW1 has said that, DW3 has said that. Those there'll be a reference to that.
Not so specifically, but Lordship, they discussed that in written statement, we have already admitted that there is an amicable partition, and thereafter we have Lordship residing in the respective plots of lands after partition which we got, Lordship, and where the other co-sharers have received their share, Lordship, they are residing there. So both the courts held that when you admitted the thing in your written statement, the same statement you cannot deny in your evidence. So we cannot, well, Lordship, move beyond pleading. That was the finding of both the courts. And in that
No,
means in
we
evidence
won't go into that aspect, because you see those are issues. If it could not have been done, explanatory written statement, additional pleadings could have been filed. So we are not on that, because those are steps which are already over. The question is whether if you could establish your definite share and dispel the claim of the plaintiffs that they were not entitled to this specific 4 plot of land, ABCD. Then you'd be able to make out. Otherwise, in second appeal,
not so Lordship, clearly
Happily worded.
editing in the Lordship.
no, but you see, we have our own limitation under section 100. We can't reopen evidence because those are all facts. The question is that on the factual aspect, you'll have to show us that even on facts, we could have we have the power to entertain a second appeal, for which the perversity is so large that it vitiates the decision of the learned trial court. Either it would be misreading of the evidence, or it would be the what you call omission to consider any evidence or pleadings on record. So if the perversity can't be shown.
As per judgment, Lordship, they have considered the evidence, but it says that, Lordship, this evidence is beyond pleading, so we could not consider those evidences in favor of the defendants, as defendants already admitted.
So then that finding won't be hit by perversity.
And
if it
defendants
is-
admitted, Lordship, my point is that defendant admitted that the plaintiff is residing in her residence. We have no objection in regard to that. So, Lordship, there are 4 schedules. Schedule A is completely cultivable land, Lordship. So my admission is not in respect to Schedule A. Maybe we are admitting Schedule B, that in that B, Lordship, schedule plaintiff is residing. So it does not mean that I have admitted the possession of the plaintiffs over all the schedules.
Shows that part of the your written statement.
Written statement, Lordship, that is in page 27,
Yes.
and video inscription, Lordship, will find page 29, para 17. That was discussed by the courts below. That the defendant number 129 accepted the para number 2 of the claim. The Pattadars were simple villagers. They amicably partitioned their landed property in various time and moment in various darks, and Pattadars belonged to their respective portion. Someone had taken his her share in one darks, and someone had taken in another darks.
So there, if suitland is to be given to the plaintiff, they also to be given up the possession of the landed property where now they were living by dwelling house as per their applicable settlement.
But Mr. Chaudhary, you take us to a very difficult task because you'll have to also demonstrate the submission which you are making in light of order 6 rule, sorry, 8 rule 5, denial should be specific. So you see, if you say something which is so vague, definitely the
Your Worship, I
question.
have already stated the written statement is not so clear about and not happily worded as your lordship said, lordship. But from the written statement, I will not got anything, lordship, only the DW portion, the clear picture comes out that the predecessor Rome was the original owner and his.
For that, before we come to your evidence, then you need to demonstrate from your cross-examination of PWs that that was successfully demolished.
But
Because if you have put that question and they have admitted it,
But in plain, they have already admitted the Jamavati contains the name of all the co-sharers.
because the smile of Mr. Bormia appears to be compassionate. He wants to give you something. No. But then why a serious smile? I thought you are unhappy with the judgment and you wanted to give something to Mrs. Chaudhary.
Why I was laughing, my lord. She's hovering in the air, man. Now she's relying on her DW mind without projecting her piece of her own mind.
No, that is okay because you see, she's answering the query of the court.
Yes, ma'am.
It's not that we are hearing everything in second appeal. So it's the court query which she is answering, and that appears to be the correct, what you call this, correct approach.
They have, the plaintiffs also admitted that the Jamavati contains the name of all the co-sharers.
No, correct. Because you see, these are something which you have dealt with. What you call, at one point of time in the civil court, one would have not become a great lawyer without handling case of Dag number 1, Patta number 1, Mozai and village, I will not say. It has led to not less than 1,000 litigations. That is one. One is an estate of a person with before whose name a prefix of doctor is there. Since I've handled those litigations, not naming them, but I think till my age group of practice, nobody has handled that and become a good civil lawyer. I don't know. You see the joint patta, the effect of partition, the effect of you see in that Dag number 1, Patta number 1, there are sale deeds which have come into existence due to power of attorneys executed in London. The person is in London, the power of attorneys are executed here. I'm sorry, not in London. Power of attorney executed here, and sale of land, widespread sale of land in Guwahati. It would have been 11 or 1200 because I forgot. Mr. Satar, how much land in one Dag number 1, Patta number 1? More than 1,000 bighas. Huh? No, that was not. It was a what do you call it? Special cultivation land. Special cultivation land. More than 1,000 bighas within the heart of Guwahati. So therefore, those parts we are aware of how the rights are created, how these pattas are to be read, how the remarks are to be construed.
In this case, there is nothing, the defendant's written statement is still about worship. There is nothing in the written statement also. There
No,
is
you see,
specific-
you see, that even if something is not in the written statement, you could have demolished it successfully in the cross-examination. Then also, at least one substantive question of law would have been developed. But in the absence of any such demolition of the case of the plaintiffs, the question of the positions and discrepancies thereof will not be so fatal. Secondly, you see, even if you assume that there is a misdescription of property, then the provisions of Order 7 Rule 3 has been interpreted by the Supreme Court and followed by this court, saying that a misdescription of the boundaries can be amended even in the execution stage. So therefore, that's why I'm saying you are taking us to a difficult task where acceptance of a submission would all be
Your
wrong.
lordship, that, page 40, para 16, your lordship may kindly see.
Page 40.
Yes, sir. 40, para 16. Trial court's decision. And last two lines, lordship, the plaintiffs have averred in their claim that although some other heirs of diseased Lume are available on record of Jamabandi, but they were not in possession at all because they took their share in other different patta of land belonging to the diseased patta holder Lume Thali Lume. Whether there was any evidence by the plaintiff, your lordship, without any effort, how a lordship trial court can held that some other parts were taken by the some other portion. There was no effort by the plaintiff in proving that we have received land in some other plots. And it is plaintiff.
No, you see, these are very difficult, difficult to immediately react to that query of yours. You see, number one, you will be better equipped with the facts. That is for sure. The second part is that I find from somewhere in the pleadings that there is a reference to 2 or 3 dag. One part of the land is in dag number 84, one is in 29, and there's another dag, I think, patta, I believe.
Number two,
No, not dag. Dag is within the patta.
patta on the 84.
No, there's reference to one more patta. I think it should be 29 or something.
The 4 schedules.
I don't know, I won't remember that much.
Lordship.
If I'm saying 29, it could be 26 also, but I don't know. There's another.
Schedule A says about on the 84. Schedule B also, lordship, patta number 18829.
So there's a different patta.
Lordship.
There'll be one more. The 29, why I'm remembering, I don't know.
Lordship, except that all patta number 84, lordship. C, D, all are patta number 84, lordship.
Yes, I said that I read somewhere. Page 15, patta number 29.
That is schedule B, lordship.
No, I don't know the schedule. You see, I don't, what do you call, I've not made it by heart and come.
Lordship.
I just read somewhere and snippets of that, what I've read remains in the mind.
Lordship. Page 15, para 2, lordship.
I don't know, but you see, this is something, Dagan patta number, I would not go into it. It is for some reason, I don't know why it retained my mind, I don't know. It was not intentional retention. It just something which stayed back.
Patta number, schedule B.
No, that's what I'm saying. You see, if people are saying that they have land in 3 dag, somebody may be occupying one patta and one dag, or one another patta, another dag. So it is an inter se arrangement between all of them. That is one part. Second part, when the plaintiff comes, they say, they refer to a given schedule. And then they say they are specifically requiring that to be decreed. Now, the question is in the, if the, in the written statement, if that can be tackled in an appropriate manner, then only then evidence can support what is there in the pleading. That's why I'm saying, you see, what I said was in a short form, I said that your argument has to be appreciated in light of order 825. Well, specific, 625 or 825, the specific denial should be specific. So, because that is the counter which I am bound. If I am looking at the issue of perversity, I have to see it with the pleadings as well as the evidence, if it has been wrongly read. And if it is not there, then the second appeal can't be admitted. Mere error in facts would not be sufficient to interfere with the concurrent finding.
But then this lordship, I have also not find anything, lordship.
Then we'll have to dismiss this demotion stage, admission stage. Yes, any compassion towards Mrs. Chaudhary?
These are my not all concurrent finding, my lord, nothing.
Okay, no compassion. He is also heartless. Had Mrs. R. Chaudhary done counsel for the appellant and Mr. J. I. Barbuya done counsel for the respondents.
Respondent 1 and 3, my.
Respondent number 1 and 3. Next paragraph. This appeal under section 100 CPC is directed against the judgment and decree dated 7/7/2023 passed by the learned civil judge within bracket senior division bracket close Morigaon in TA number 15 of 2019 by the said appellate judgment, comma, the appeal of the appellants herein was dismissed and the judgment and decree dated 25/2019 passed by the learned Munsif number 1, give first bracket, second bracket, now designated as civil judge within bracket junior division bracket close number 1, Morika Assam in TS number 52 of 2016, by which the suit of the respondents was decreed. Full stop. The concrete finding of the learned courts below is assailed by the appellants on the strength of the five substantial questions of law as formulated by the learned counsel for the appellant, which are as follows. Page 4, flag. Next paragraph. The three respondents the respondent numbers 1, 2, and 3 are the plaintiffs in TS 104 of 2016 in the plaint. There are 17 principal defendants and 13 pro forma defendants. Full stop. The suit was for declaration of right, title and interest and recovery of possession, as well as decree for permanent injunction in respect of land described in Schedule A, B, and C of the plaint. Full stop. The suit land. The three plots of the three piece and parcel of suit land. Three parcels, just strike it out. So, Schedule A suit land is a plot of land measuring 1 katha out of 10 bigha 3 katha 8 lecha, covered by dag number 243, pata number 84, and 12 lecha out of 2 katha 6 lecha, covered by dag number. You will find this in page 23. Schedule A, shall we don't give that boundary A, B, and C. A, B, C, and D. Page 23 onwards. Full stop. The four boundaries as mentioned in the plaint are not reiterated herein. Full stop. It is claimed that the original patadar of the suit land was one Rumed Ali, R-U-M-E-D, Ali, alias Rume, R-U-M-E. And that it is projected that the suit land was occupied by various persons, and all the legal heirs of the deceased patadar took possession of land irrespective of their specific share in a particular dag and particular pata. And it was projected in the plaint that the heirs of the original patadar had amicably partitioned the land in various point of time. So, specific plots of land were sought to be sold by one Zakir Hussain. This Zakir Hussain itself is not a party here.
Zakir Hussain sold also. Zakir sold.
No.
90 property.
No, I don't know. I'm still in paragraph 4. In paragraph 4, it says, while in possession, the pata holder Zakir Hussain, son of so-and-so, wanted to sell a plot of land.
Russia.
Sold till now, I have not got.
Later project.
Huh?
Zakir sold to 20 property.
No, that I don't know. I have not I told you I have not remembered it by heart. I'm just refreshing my memory while I'm writing. But this Zakir Hussain is not a party here. There's two spellings of Zakir Hussain, Zakir, and one is Zakir, which is right. And where is that person in the cause title of the plaint? So to the plaintiff number 2. And accordingly, cell permission was issued. And they said Zakir Hussain. Now, which is the correct spelling, J or Z? Zakir Hussain.
You have named as ZAKIR, page 11.
No, in para 4, you see JAK. First line is JAKIR. Second, fifth line, it is Zakir, ZAKIR. So what should I write now?
ZAKIR.
Okay, ZAKIR. Within bracket, also spelled as Zakir, JAKIR. Bracket close. And accordingly, on the basis of cell permission, the said Zakir Hussain sold the Schedule A land by registered sale deed number 2053 of 2004 and delivered possession thereof to the plaintiff number 2. And subsequently, the said land was mutated in the name of plaintiff number 2. Full stop. Similarly, another patta holder, Musammat MUS double T, Sakina Khatun, SAKINA Khatun, sold 17 acres of land by registered sale deed number 2328 of 2006, dated 17/11/2006. And the land got mutated in the name of plaintiff number 2. And another patta holder, Abdul Rashid, RASHID, sold 3 kata, 9.5 lecha land by registered sale deed number 10836 of 1968 to the Musammat MUSSTT Kadbanu KADBNU Bewa. And out of her land holding, which included the purchased land, Kadbanu Bewa, sold 4 acres of land to Ismail Ali, ISMAIL Ali, father of plaintiff number 1 and husband of plaintiff number 2, by executing registered sale deed number 107 of 1978. You see, that is why when I'm writing, I'm finding it very difficult. You see, it's stated in Oh, acha, his husband of plaintiff number 2. Okay, okay, right.
father
No, it's okay. And husband of plaintiff number 2 by registered salary number 107 of 1978. And after his demise, it is projected that the plaintiffs were in possession of that land. Full stop. Another Pattada, namely Abdul Hamid, had sold 1 kata 6 lecha land to the father of plaintiff numbers 2 and 3 by the registered sale deed number 1536 of 1981. And after the demise of their father, the plaintiff number 3 is in possession of this said land, and which is duly mutated in his name. Accordingly, it was claimed in the plaint that the plaintiffs were possessing suit land described in Schedule A, B, C, and D. And as the principal defendants encroached and constructed a hut over the Schedule A land on 29 to 2016, and further alleging that land described in Schedule D was also occupied by the principal defendants, B, C, and D, the present suit was, the said suit was filed for declaration, recovery of possession, and permanent injunction. Full stop. The appearance the appellants had filed a joint written statement along with 9 others. Most of the appellants were defendant numbers 4 and 5 respectively. Apart from taking a defense that the suit was hit by adverse position, and accepted the amicable partition of the suit land, but took a plea that if the suit land was given to the plaintiff, they would be deemed to have given a possession of the landed property where they were living as per the amicable settlement. Full stop. The defendant numbers 1 to 9 took a plea that it was required to be ascertained as to whether all the sale deeds were correct and the seller had the power to make the sale or not. And it was stated that it was not correct that the plaintiffs had purchased the land from not correct, and that they had purchased land from persons who had no right to sell. And accordingly, the defendant numbers 1 to 9, including the appellants, prayed for dismissal of the suit. Next, we done it. We'll continue at 2.
Obliged, sir.
In course of trial, the learned trial court had framed the following issues. Page 37, flag. So the plaintiff's side examined 4 witnesses, namely, so page 49, and exhibited the following documents, same page 49. And the defendant's side had examined 2 witnesses, namely so and exhibited 3 documents, violate so page 49. Full stop. Well, issue number 1 relating to cause of action was decided in the affirmative and in favor of the plaintiff. Comma. Not while, strike out while. So in respect of issue numbers 2 and 5, which was taken up together, comma, the learned trial court examined the pleadings and the evidence and arrived at a finding that the plaintiffs had purchased the suit land on the basis of, on the strength of 4 sale deeds referred herein before, and the land were duly mutated in the respective names. And accordingly, it was held that the plaintiffs had discharged their initial burden by proving Exhibit 2 and Exhibit 9. Moreover, comma, it was held that the defendants could not discharge their burden to show that Exhibit 2 was forged and accordingly it was held that the a document which is validly executed and registered would prima facie be valid in law. In connection with this said issue, comma, the learned trial court held that the evidence of BW 1 and 2 remained unimpeached, and it was further held that the BW 4 had proved the execution and registration of sale deed marked as Exhibit 11. And it also proved the description of the land by producing and exhibiting a draft chita of dark number 204, 205 and 206 as Exhibit 4. And accordingly, on the basis of Exhibit 11 and Exhibit 4, it was held that PW2 had acquired the right title and interest over land described in Schedule B. First off, on the strength of Exhibit 5, which was the registered sale deed number 107 of 1978.
Of 68, my lord.
Pardon me,
Page 49, my lord, it reveals original registered sale deed 1088 of 1968. Page 49.
which was registered sale deed number 10836 of 1968. It was held that the plaintiff numbers 1 and 2 had also acquired right title and interest over land described in Schedule C of the plaint. As it was also held that the defendants could not be able to prove that the sale deeds marked as Exhibit 5 and Exhibit 6 were forged. And it was also observed that the defendants had not challenged the genuineness of the sale deeds, and accordingly, presumption of lawful execution and genuineness of the signature was presumed in respect of the document which was 30 years old. And accordingly, it was held that the plaintiffs had acquired right title and interest over the suit land described in Schedule C by way of inheritance. Full stop. Resulted, comma. The issue numbers 2 and 5 were decided in the affirmative and in favor of the plaintiffs. Full stop. The in respect of issue numbers 4, the issue number 4, comma, the learned trial court had held that the plaintiffs were peacefully possessing land described in Schedule A, B, C, and D by their own right, title, and interest, and that they were forcibly evicted from their and that the land was illegally occupied by the defendants. And having regard to the certified copy of Miskis number 10 of 2007, within bracket Exhibit 7, comma, denial by the defendants was viewed as if the defendant side had not been able to rebut the allegations of disposition, and accordingly, in view of the admissions made by the defendant, by the DW1 and the testimonies of the PWs, the issue was decided in the affirmative and in favor of the plaintiffs, and accordingly, the right title and interest of the plaintiffs in respect of Schedule A, B, C, and D land was declared. With the finding that the plaintiff numbers 2 and 3 were entitled to recovery of possession of the Schedule D land, and the plaintiff numbers 1 and 2 were entitled to possession of Schedule C land. And that the plaintiff, make it serial. The plaintiff number 2 was entitled to recovery of possession of the Schedule A and B land. That is first. And they were also entitled to, and the plaintiff number 2 was also found entitled to decree for permanent injunction. And right title and interest was declared in favor of plaintiff number 2 in respect of Schedule A and B land. First one. Similarly, it was held that the plaintiff numbers 1 and 2 had right title and interest over the Schedule C land, and they were entitled to recovery of possession of the said land. And the defendants were permanently restrained from entering into the Schedule C land. Moreover, it was held that the plaintiff numbers 2 and 3 were entitled to recovery of possession of the Schedule D land, and they were also entitled to permanent injunction by restraining the defendants from entering into the Schedule D land. Next part, the decree by the learned trial court was unsuccessfully challenged by the appellant before the learned first appellate court. First of all, the learned first appellate court by the impugned appellate judgment and decree dated 7/7/2023 dismissed the appeal, being title appeal number 15 of 2019. First, it would suffice to mention that the learned first appellate court formulated the following point of determination, page 82. First of all, the learned first appellate court had revisited all the issues, and by its own appreciation of the pleadings and evidence on record, affirm the finding of the learned trial court on all the issues. And thereupon dismiss the appeal. Next paragraph. In support of the substantive questions of law framed by the, as formulated by the learned counsel for the appellant, she had referred to the pleadings of the parties as well as the evidence on record. Sorry, and also referred to the evidence of the witnesses. Full stop. Based on the pleadings on record, the learned counsel for the appellants could not successfully demonstrate that the learned trial court or the learned first appellate court had failed in considering the various pleadings and evidence in its proper perspective. Full stop. The maybe mentioned that in the written statement filed by the nine defendants, they had merely taken a plea of denial. And claimed that the registered sale deeds are not of any value in the eye of law. First of, the said defendants had not set up their own case and merely asserted that they had become absolute owners of the land on the ground of adverse possession. Full stop. Therefore, the court is not convinced that any pleadings or evidence were not read by the learned trial court or the learned first appellate court in its proper perspective. Next, in support of the substantial question of law number 2 as formulated by the learned counsel of the appellant, it is noted that the plea has been taken at the second appellate stage regarding non-maintainability of the suit for misjoinder of parties and misjoinder of various causes of action. In this regard, it was submitted that there are four separate sale deeds by the respective in favor of the respective plaintiffs, and therefore the cause of action could not have been joined together. In respect of the said issue as raised by the learned counsel for the appellants, Now the court finds that at the initial stage of the suit, the appellants as defendants had not raised the issue of joinder of plaintiffs. And therefore, at this step, second appellate stage, the court is unable to return a finding that the joinder of plaintiffs had resulted in any embarrassment or delay in the trial of the suit. So had the said point been raised at the trial stage, it would have been open to the learned trial court to take recourse to the provisions of Order 1, Rule 2 of the Civil Procedure Code and order separate trials. First of the same having not been done at an appropriate stage, it is for the appellants to demonstrate that the prejudice that they had suffered in course of trial was irreversible. First, there's nothing on record to show that the appellants had suffered any prejudice merely because of joinder of causes of action or joinder of plaintiffs in the trial. First, therefore, the said plea is found to be unacceptable at the second appellate stage. First, in respect of the misjoinder of necessary parties, in this regard also the court finds that there is no pleading in the written statement to show that who ought to have been joined as defendants or plaintiffs in the suit. First, therefore, the vague plea of misjoinder of parties is not sufficient for this court to interfere with the concurrent finding of facts on all the issues written by the learned trial court and the learned first appellate court. Therefore, the plea taken by the appellants is not found sustainable. Next, in respect of the substantial question of law number 3, as formulated by the learned counsel for the appellants, it is observed that in the written statement, a mere plea is taken that the defendants had perfected their position and that within the meaning of Article 65 of the Limitation Act, without any basic pleadings as to the date on which the claim of adverse possession claim to operate. So no counterclaim was preferred by the appellants / defendants to assert their claim over the suit land by application of the principles of Article 65 of the Schedule to the Limitation Act 1963. So therefore, the point raised by the learned counsel for the appellants does not find favor with the court for admission of this appeal on the ground of the perfection of the title of the petitioner of the appellants under Article 65 of the Limitation Act. Full stop. In respect of fourth substantial questions of law, as formulated by the learned counsel for the appellants, it is noticed that the witnesses of the plaintiffs are exhibited the four sale deeds, which are marked as exhibit 2, exhibit numbers 2, 5, 8, and 11. First off, it could not be demonstrated that any effective by any effective cross-examination, the legality and validity of the said sale deed could be dispelled. Therefore, the court is constrained to hold that the applicants have not been able to demonstrate that the learned trial court or the learned first appellate court committed any perversity in appreciating the exhibits 2, 5, 8, and 11. First off, it may be mentioned that in the question formulated by the learned counsel for the applicants, reference is made to the proof of exhibit 2, 5, 6, and 8 as original registered sale deeds. Apparently the same is incorrect, as it appears that the original sale deeds were exhibit 2, 5, 8, and 11 respectively. First off, therefore, the submissions made by the counsel for the appellants is not found sustainable that the said exhibits were admitted without any valid proof. Full stop. Next paragraph. No other substantial question of law could be raised at the time of hearing. Next paragraph. In view of the discussions above, the court is disinclined to admit this appeal. First of the court has not been able to, the appellants have not been able to demonstrate that any substantial question of law has arisen for decision in this appeal, and therefore the appeal is found not maintainable, and accordingly this appeal stands dismissed at the admission stage without issuance of notice on the respondents. So let a formal decree be drawn up and transmitted to the learned courts below for making it a part of relevant records.
In view of the order passed, my lord, the IA is also pleased.
They will do it. They will do it. Item
Except
2.
This matter, marriage was solemnized between the parties going back from 19/4/2019, and admittedly the marriage was not consummated. Somehow they lived for 7 months, and thereafter the respondent number 2 out for voluntary going. He left the matrimonial home on 1/11/2019. Thereafter, the petitioner tried his level best to bring her back. In fact, he has also sent a legal notice on 9/2/2023 seeking restitution of conjugal rights. But thereafter, on 27/2/2023, he has filed a petition of divorce.
There was a delay in filing this application that perhaps is referring to.
So now this is for admission today, for enhancement. Then
For
leave-
you to kind of fetch, you could the land.
Oh, that's why I'm asking you, did you take instructions? You see, I have told you in the morning, if you withdraw this, the new limitation act will apply for filing of the case. If you are ready to take it, we are ready to hand it over to you. You see, a limitation, you see, the court, while granting you leave to withdraw and to file again, will not have jurisdiction to condone the delay. And whether delay in the original application can be condoned under Section 5, that is something I am yet to understand. No, Liberty, we are ready. Okay, then we just give it to you. But it won't do you any good. Is it 2000? Right? But this will be difficult to accept. That on register, they shall be bound to register. You see, registration can be always made. It doesn't refer to the condemnation. So you see, you go to any court today. Let us say you file a claim. Let us assume something very strange. You see, you say that in 1947 some right accrued to you in respect of a plot of land which is measuring 1 katha, and you want to go to a civil court and file a suit. Now tell me, will a civil court refuse to accept that suit? Even you are making a claim of 1947, your right, your cause of action arose in 1947, your suit will be registered. But again, in trial, it will be dismissed for barred by limitation. Your limitation is 3 years if you want to have assertion on title. If it's based on Article 64, 65, it is 12 years. Otherwise, the limitations are there. So bound to be registered, court shall be bound to register is something else. And be bound to entertain and decree it, that is something else. Correct? So that's why I'm telling you, we take a conscious decision and do it. No, you see, you should be scared. Because we told you earlier, take a conscious decision. You could have made a prayer before the learned trial court for transfer of the proceedings. You're not seeking a transfer, you are seeking a withdrawal of the suit. Once you withdraw it, your cause of action will expire. You can't save it.
The suit was already withdrawn.
We don't know about that. We are just telling you, please take a conscious decision, take a well-advised decision. Because I am ready to allow your application. Yet I am refraining myself. I don't want young people to suffer because of because you have made a prayer. You have said you want this prayer, I am ready to allow it. But the question is whether you would be doing, you're taking an appropriate step. The answer would be no. Because the period of limitation cannot be extended merely because you have withdrawn it. The cause of action cannot be, the period of limitation cannot be extended by a mere order of allowing your withdrawal. You can seek a transfer, that is something else, but it will have to come in different jurisdiction. Take a conscious decision. It's not a question of being scared. It's a question of being well informed and having what you call clear concept of the legal provision. Correct? Don't be scared. You should acquaint yourself with the legal position. Correct? Take a conscious decision. We'll take it up day after tomorrow, based on day after tomorrow, 20. Spirit for Bell and counsel for the petitioner, Mr. M. Tatal, and counsel for the respondent is present. Respondent number 1 is present. Okay. Yes, item 27.
The second appeal is preferred by the defendant's appellants against the concurrent findings.
Yes, what is the ground?
At page 5. Page 11. Whether the burden of proof lies upon the plaintiffs to establish the alleged fraud in execution of sale is Exhibit A and Exhibit B, that is research sale deed under Section 101 of Evidence Act, and in the absence of discharge of the said burden of proof, the impugned judgment are not sustainable in law. Whether the Exhibit 4 and Exhibit 5.
Please elaborate. Who will prove the fraud?
The learned court below, the courts below, say that there is a fraudulence. It is there, neither plaintiff pleaded for fraud. The courts of its own say that it is a case of fraud without evidence. It is a sale deed was shown to be executed. Their statement was that it was a loan document, not a sale deed. That is why they have signed it. He signed it, PW4. So when it was signed, contents of the said document, Exhibit A or Exhibit 5, or Exhibit B or Exhibit 6, these are all certified copies. They did not dispute the signature of the sale deed. But contents, they said it was a loan application, not a sale deed. So burden lies upon them under Section 77 of the Evidence Act.
How did the trial court discuss this issue of fraud?
For trial court at page 3.
That is issue number 3.
Issue number 3.
Yes.
Issue number 2, cause of action, that was there, no problem. Issue number 3 at page 949. The plaintiff number 4 did not execute sale deed so and so, so and so, so and so. Whether the sale deed number so and so is a fraudulent. In view of the discussion arrived to issue number 2, I hold that the board the sale deed 1763 of the 14 over 798/14 was fraudulent executed, hence they are liable to be cancelled. Accordingly, we have to go back to that now position. Decision number 2. Whether the plaintiff number 4 have executed the sale deed so and so, so and so. The existence of sale deed so and so is same executed irrespective of the fact that whether they were executed legally or not by the plaintiff 4. But the plaintiff specifically pleaded that defendant number 1 and 2 taking advantage of plaintiff number 2, who is an old, ailing, illiterate, simple, rustic village lady, with a promise to provide a bank loan to her, took signatures on some blank papers, Indian judicial stamp papers, on some printed forms, and then they, without any knowledge of all the plaintiff, they converted into those side papers into a sale deeds, Indian names. From the evidence of the plaintiff, it is evident that the predecessor of the plaintiff, Tita Mohan Roy, purchased Sutland, Schedule A, Bhai Register Siddharth, so and so, who executed the father of the defendant number 4. Exhibit number 1 proofs in this fact. Existence of proofs that Tita Mohan Roy purchased the sale deed by Register number so and so from the same person. Exhibit 2 proofs that in view of the challenging disproving the said fact by plaintiffs and performed defendant, it is established that entire A and B lands were purchased by Tita Mohan Roy. Interestingly, this above fact was admitted by DW in his cross examination, who is a co-villager of the village plaintiffs. The evidence of DW1 cannot disprove the said evidence of plaintiff, as he seems to be ignorant from whom the plaintiff acquired the right title interest over the land. He even did not know who was Tita Mohan Roy. Therefore, it can be presumed that
before allegedly purchasing the suit land by registered deed number exhibit A, sale deed, the defendant number did not inquire how the plaintiff 4 had acquired the rental interest over the same. The evidence on record proves that the plaintiff number 4 is the wife of Peter Mohan Roy, and the other plaintiffs are sons and daughters, respectively. Therefore, as per Hindu Succession Act 1956, after the death of Peter Mohan Roy, the plaintiff shall inherit the Schedule A and B land as legal heirs. In other words, all the plaintiffs shall exercise their right to the interest over the suit land as per law of succession applicable to them, not alone by the plaintiff 4. Since the plaintiff averred the suit land suit has not been partitioned among them, there is no evidence to disprove the said fact. Therefore, it can be safely presumed that they are all jointly possessing the same. Therefore, the plaintiff 4 alone had no right to sell the suit land as alleged until and unless it is pleaded and proved that the other 3 different plaintiffs have abandoned or relinquished their share of land in favor of plaintiff 4. Another aspect which is required to be discussed here is that defendant number 2 stated to have purchased the suit land by him, and the defendant number 1 through the aforesaid sale deeds from the plaintiff 4 after obtaining due permission from the concerned authority and delivered possession to them. However, to prove that at the time of alleged sale made by the plaintiff number 4, she has absolute right to the interest of and possession of the execution with exclusion to the other plaintiffs. The defendant have failed to adduce any evidence. In fact, there is no such pleading in the written statement that the plaintiff 4 was the absolute right to the interest and possession holder of the suit land. With respect to defendant number 1 and DW 2, it can be said that he has failed to file his written statement. Therefore, his evidence cannot help him to establishing the fact stated in his affidavit evidence. Moreover, though the defendant number 2, DW1, stated many things in his affidavit evidence supporting the case of defendant number 1, those facts cannot be entertained favoring the defendant number 1 as they did not file his written statement jointly. With respect to possessory right, it is observed that the plaintiffs claim to have been possessing the suit land and prayed for declaration of to that effect. On the other hand, defendant number 2 also stated to have been possessing the suit land. If that be so, he has no dispute with all the plaintiffs. In fact, did not challenging the injunction order so and so against the defendant number 1 and 2, or P number 1 and 2 in the said cases, restraining them from entertaining suit land and disposes the disturb the petitioner till disposal of the suit, also indicate that they were not in possession of the suit land. Therefore, the pleading and written statements after the purchase of the suit land by exhibit A by the defendant number 2 had been possession is not believable. With respect to defendant number 1, it can be said that the suit is proceeding expertly against him enough, even though he examined himself as the DW2, claiming to be purchased the Schedule B land by the exhibit A, sale deed, they do not carry any meaning. He cannot lead any evidence in this without pleadings in the form of written statement. Upon the consideration of this one, so report, in view of the following discussion, I have come to conclusion. Both the defendant number 1 and 2 have collusively executed exhibit A, exhibit B sale deeds. According to this issue decided negative in favor of plaintiff and against the defendants. So there is no evidence to that effect that there is a fraud. There is sale deed, registered sale deed in the name of defendant number 1 and 2.
You have a copy of that sale deed?
Right now, I do not have. Signature is admitted by the plaintiff number 4. And plaintiff number 4 was the only sole name, her name was only there in the revenue document. 27 years passed after the death of their father. They did not mutate their names. Defendant number 1, the plaintiff number 1 to 3. It was only in the name of plaintiff number 4, mother. Yes, they may. In that case, by that sale deed, 2 sale deeds, at least the plaintiff number 4 has right to sell her share of property. Suit cannot be dismissed as against, should have been decreed against the defendants. In respect of the mother's share, at least should have been allowed. At page 11, substantial questions are there, Lordship. These certified copies were never proved by calling official witnesses by the plaintiffs.
Which one?
Certified copy, exhibit 4 or exhibit 5. Exhibit 4 and 5 correspondingly.
No, what is that?
exhibit
It's very difficult to understand. What is 4 and what is 5?
Exhibit 4 in the name of defendant number 1, Exhibit 5 in the name of defendant number 2, which corresponds to Exhibit A or Exhibit B, which is filed by the defendants. Therefore, Exhibit 4 equates with the Exhibit A. Exhibit 4, Exhibit 5 equates with the Exhibit B.
No, that can't happen. This, you see, if two people are exhibiting the same document, one has to be a certified copy, not the original one. There can't be two originals.
No, given that when the plaintiff exhibit the same, they got to call the official witnesses for proving the same.
So plaintiff were exhibited what? Certified copies.
Certified copies. They did not call for the official witnesses. And PW4 in our evidence admitted that I signed it.
No, those are not available. How can I read that? You have not given that evidence.
In that case, Lordship, they may be fixed so that I can bring all those things into the honorable court.
Because the sale deed is not there. What has proved, we don't know. In the trial court judgment, the list of the appendix is not there. Even you have not filed any list of appendix, so therefore I'm unable to find out what is what.
I shall, in that case, exhibit trial court judgment. The page is not there.
No, because you see, whatever you are saying is very difficult to follow. I'll tell you why. Come to page 71, for example.
Page 53.
Come to page 71, I'll show you why.
Appellate judgment.
Whatever be, I'm not very sure. At random, I have taken out a page. Page 71. Page 71, para 13 says, PW1 exhibited certified copy of the registered sale deed number so-and-so and exhibit 1 and registered sale deed number so-and-so to prove the fact that the suit land was originally purchased by his father. Further, the certified copy of the draft Jamabandi is exhibit 7. In his cross-examination, so-and-so deposited he could learn from the suit land by recording the father's name and subsequently his mother's name was recorded in his land. He denied submitting any petition before the authority to mutate their names. Correct. So now they are projecting that if somebody is claiming that the mother's name was there and the land belongs to the father, that means there is an exclusion of a sharer from that land.
No, their names were not shown to be mutated in the year 1990 when the father died. It should have been mutated in all the 4 legal years. Those sons.
Because you see, then in para 16, it says in a cross-examination, she is clearly denied signing exhibit 5 and 6, which are registered sale deeds. So she is denied the execution, the mother of so-and-so. So if the mother is denied and it could not be proved that it could not be dispelled. So the denial would.
There is no signature, as the only sign, as the. So therefore, it needs to be brought by your official, calling your official witnesses.
No, that I don't know. I can't presume anything because you see that the court is accepting that position where it says that the witness has denied it. And the witness is the owner of the land. She denies execution of the sale deed.
No. In PW4 in evidence, she has said that I have signed certain documents, but it was only for the purpose of taking loan. Not
I don't know. I'm just reading paragraph 16. That's why. You see, I'm only reading what is there.
Read the evidence also. And the document to sell it also.
Do it because it has to be convincing when I'm admitting a second appeal.
Again, otherwise also register sale deed is there, rightly, wrongly, if it was executed, that my right cannot go simply because just because I'm playing fraud has not been defined by them, has not been stated by them. How in which way I have committed fraud on them?
No, I can't make up my mind. Please try to understand when I'm reading that evidence which says that the witness has denied executing the sale deed.
In that case, I shall bring the political sale deeds.
When do you want the matter to be taken up?
Lordship, in that case,
After vacation. Okay. As prayed for by Mr. B.K. Bhagwati, counsel for the appellants, is permitted to bring on record any additional document on which he intends to rely on by way of an additional affidavit. Next, as prayed for list. When? After ensuing winter vacation. Yes.
My lord, my employee had filed one complaint that his December month salary has not been paid. And then your lordship will be pleased to see at, in the form of annexure 1 at page number 12.
Page
Page 12, my lord.
12.
Sorry, page 14, my lord. Page 14.
Okay.
Page 14, my lord. My lord, this complaint was filed on 17/3/2017. At the top of the complaint, my lord, the date is mentioned, 17/3/2017.
Yes.
This complaint was filed, and the gist of that complaint, my lord, is it is to inform you that I was employee of Candida Enterprise of Kaliram Medi Road, Ranibari, Panbizar, Guwahati, Assam, since 1990. But due to some problem, I have resigned from Candida Enterprise, which is with effect from 1/1/2017. 1/1/2017. But in spite of several reminders and requests, I have not received my salary for the month of December 2016, as well as other benefits. In spite of several reminders and requests, they did not bother to any reply and settle my account. Also inform you that I do not have any loan and impressed with Candida Enterprise. Further, you are hereby informed you that my old parents are suffering from various disease and I have to spend huge money for their treatment. And now operation is necessary. Kidney stone. As per advice of the doctors, I am enclosing here with prescription and diagnosis reports of my parents for your kind perusal. Under such situation, you are requested to take positive steps so that I can receive my all the dues immediately from Candida Enterprise. And after receiving my dues,
Payment
I
of
can
wages,
give better treatment of my
Payment of
old
Wages
parents.
Act.
I am enclosing here with my registration, resignation letter, and all correspondence letter with the Candida for your ready reference. My lord, on the basis of this complaint, which was addressed to the Assistant Level Commissioner, the Assistant Level Commissioner, my lord, registered a case bearing case number LPW case number 2/2016, annexure 3.
Does it go to the district judge? Appeal.
My lord,
Is appeal entertained by a district judge?
district. As per 17, my lord, section 17 of the Payment of Wages Act. May I read that section 17?
I'm just trying to understand the scope of this appeal, the second appeal,
My lord.
because this appeal is before the district court.
It is against the judgment of the district court. my lord.
Yes, but whether second appeal is permitted? Is it permissible? Second appeal before the High Court?
My lord, because the first appeal was before the district judge. So my lord, it has come in the form of RSS second appeal.
It cannot come. Because you see, appeal, what do you call the second appeal, we entertain is section under section 100.
Right.
Now, merely because an appeal is before the district judge, will it become an appeal under section 96? If it is not an appeal under section 96, an appeal under this special statute, then second appeal would not lie. Then this award has to be challenged either in a writ petition, I don't know. because it will not be, you see, why I'm saying so is that
My lord.
under the civil, this, what you call the High Court rules, number one, we don't have superintending jurisdiction before the labor court. We don't have. And therefore, if the appeal is not, appeal under section 17, if it is not appeal within the meaning of section 96, then perhaps second appeal within the scope of 100 would not be available. That is subject to correction, because this is something I've never
Yes.
dealt with earlier.
Should I take your lordship to section 96, though your lordship has gone through that many a time?
Yes.
96 of this.
Yes, yes.
Save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. 2. An appeal may lie from an original decree passed ex parte. No appeal shall lie from a decree passed by the court with the consent of parties. 3, my lord. 4. No appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by courts of small causes when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. This was my lord. So, here, my lord, no appeal shall lie except on question of law. Question of law from a decree in any suit of the nature.
You see, Mr. Star, please bear with me when I'm again reading this section 96. 96 by its nomenclature says appeal from an original decree.
True.
So order passed by a labor commissioner in respect of the payment of wages is not a decree, number one. Then it says the section 100 which we are reading, if we come back to that,
My lord, section 100.
yes,
Same
here
as-
is also again from every decree passed in appeal where a court subordinate. So what you call, so far as I understand, the statutory appeal which is provided will because you see the character is not civil decree within the meaning of, because decree, if we understand, it is within the meaning of 2(2). And if it is not a civil code within the meaning of this Agra Bengal Assam Civil Codes Act, to entertain this challenge as a second appeal, because you see, insofar as the RERA is concerned, the new act, which 2 or 3 matters have come, there it says that the in the RERA appeal, it says that principles of section 100 will apply. So there's specific provision given for the purpose of admission of the appeal within the meaning of section 100. So the what you call,
Regulation itself. That's the regulation itself.
yes. So therefore, to infer that a second appeal within the meaning of 100 would lie in against this. Because normally against the order of industrial tribunal and the labor court, normally we find writ petitions being entertained. Subject to correction, because this is something I have never, I did not examine.
My lord, may I read this section 100? for
Yes,
the
yes, yes.
section of the lordship? Save as otherwise expressly provided in the body of this code or by any other law for the time being in force. An appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantive question of law. So that appeal, my lord, was rejected by the district court in Levine. So this section 100 subclause 1, save as otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court. So that was an appeal wherein a decree was ought to have been passed or not passed, and in that way, my lord, the second appeal. Every decree passed in appeal. Question is, my lord, every decree.
But you see in this act,
Payment of wages act, my lord.
Payment of Wages Act,
Yes.
will
Sir, my lord, whether your lordship is taking up section 17.
yes, any provision you want me to read?
No, no, no. Whether your lordship is looking at section 17 of that payment of wages act or.
No, no, the jurisdiction of, the jurisdiction part I'm trying to examine.
There is part for truth, no doubt, my lord.
Yes, I found it. Now under section 20,
My lord.
because this, if I understood it correctly, this section 90 has been repealed, which is power to recover from an employee in certain cases. So that employer power has been taken away. Now come to 20 and then come to subsection 6.
Yes, my lord.
If any person willfully pays or to pay the wages of any employed person by a date fixed by the authority on this behalf, he shall without prejudice to any action that may be taken against him be punishable with additional fine which may extend to so and so
Sir, yes.
for each day of such failure. So you see, if there is a decree, the enforceability of the decree is also a subject. The enforceability of decree itself is not provided for. It says that you have given a time. If you don't pay within that time, then you will be imposed a penalty of so and so rupees per day.
That is regarding penalty.
There is a penalty. So therefore, where is the question of enforcement? Because in a decree has to be executed.
My lord, I would like to take your lordship to section 15.
15.
Yes.
Yes.
Claims arising out of deductions from wages or delay in payment of wages and penalty for malicious or vexatious claims.
Yes.
The appropriate government may by notification in the official gazette appoint any commissioner for workman compensation or any officer of the central government exercising functions as 1. Regional labor commissioner or assistant labor commissioner with at least 2 years experience, or any officer of the state government not below the rank of assistant labor commissioner with at least 2 years experience. Now, D, a presiding officer of any labor court or industrial tribunal constituted under the Industrial Dispute Act 1947 or under any corresponding law relating to the investigation and settlement of industrial disputes in force in the state, or any other officer with experience as a judge of a civil court or a judicial magistrate has the authority to hear and decide for any specified area all claims arising out of deductions from the wages or delay in payment of the wages of persons employed or paid in that area, including all matters incidental to such claims. Provided that where the appropriate government considers it necessary so to do, it may appoint more than one authority for any specified area and may by general or special order provide for the distribution or allocation of work to be performed by them under this act. Where contrary to the provisions of this act, any deduction has been made from the wages of an employed person, or any payment of wages has been delayed, such person himself or any legal practitioner or any official of a registered trade union authorized in writing to act on his behalf, or any inspector under this act, or any other person acting with the permission of the authority appointed under subsection 1 may apply to such authority for a direction under subsection 3, provided that every such application shall be presented within 12 months from the date on which the deduction from the wages was made, or from the date on which the payment of the wages was due to be made, as the case may be. This is the limitation, my lord.
Yes.
Provided further that any application may be admitted after the set period of 12 months, when the applicant satisfies the authority that he had sufficient cause for not making the application within such period. When any application under subsection 2 is entertained, the authority shall hear the applicant and the employer or other person responsible for the payment of wages under section 3, or give them an opportunity of being heard, and after such further inquiry, if any, as may be necessary, may, without prejudice to any other penalty to which such employer or other person is liable under this act, direct the refund to the employed person of the amount deducted, or the payment of the delayed wages, together with the payment of such compensation as the authority may think fit, not exceeding 10 times the amount deducted in the former case, and not exceeding 3,000 rupees, but not less than 1,500 rupees in the latter. And even if the amount deducted or delayed wages are paid before the disposal of the application, direct the payment of such compensation as the authority may think fit, not exceeding 2,000 rupees. Provided that a claim under this act shall be disposed of as far as practicable within a period of 3 months from the date of registration of the claim by the authority. Provided further that the period of 3 months may be extended if both parties to the dispute agree for any bona fide reason to be recorded by the authority, that the said period of 3 months may be extended to such period as may be necessary to dispose of the application in a just manner. Provided also that no direction for the payment of compensation shall be made in the case of delayed wages, if the authority is satisfied that the delay was due to a bona fide error or bona fide dispute as to the amount payable to the employed person, or the occurrence of an emergency, or the existence of exceptional circumstances, the person responsible for the payment of the wages was unable, in spite of exercising reasonable diligence, or the failure of the employed person to apply for an accept payment. If the authority hearing an application under this section is satisfied that the application was earlier malicious, or either malicious or vexatious, the authority may direct that a penalty not exceeding 300 rupees, not exceeding 375 rupees be paid to the employer or other person responsible for the payment of wages by the person presenting the application, or that in any case in which compensation is directed to be paid under subsection 3, the applicant ought not to have been compelled to seek redress under this section. The authority may direct that a penalty not exceeding 375 rupees be paid to the appropriate government by the employer or other person responsible for the payment of wages. 4A. Where there is any dispute as to the person or persons being the legal representative or representative of the employer or of the employed person, the decision of the authority on such dispute shall be final. Any inquiry under this section shall be deemed to be a judicial proceeding within the meaning of section 193, 219, and 228 of Indian Penal Code. Any amount directed to be paid under this section may be recovered if the authority is a magistrate by the authority as if it were a fine imposed by him as magistrate, and if the authority is not magistrate, by any magistrate to whom the authority makes application in this behalf, and if it were a fine imposed by such magistrate. My lord, mine was a case wherein the complaint was that though I have resigned in the month of December itself, but my salary for the month of December 2016 is not paid. And that complaint was made before the Labor Commissioner, my lord, or Assistant Labor Commissioner, on 17/3/2017, 3 months after the resignation taking effect of. Now, my lord, on the basis of that, a case is registered. That's what I wanted to pinpoint before your lordship. That on the basis of that complaint, a case is registered, which is number LPG number 2 of 2016. 2016, not of 17, 2016. And my lord will be astonished to know that he is claiming the salary for the month of December 2016, along with the other wages. My lord, if I can take your lordship to page number 33.
No, that is the other part.
Other,
We go into the merit only on the first hurdle being crossed. You see, the point which I'm trying to clarify from you is number one.
whether
The-
RSA,
No, I'll tell you why. I'll just reframe my statements. You see, both under section 96 as well as under section 100 CPC, what is envisaged is an appeal against a decree. Now, admittedly, when an order of payment of wages is passed, it's an order which is enforceable by way of fine, and therefore decree is never prepared. It's never drawn up, and therefore, now to accept this appeal would be to do something which the law does not envisage. Therefore, I'll be reading this word decree as if it is an order. Because you see, under these principles of CPC, there are certain orders which are appealable as orders, and therefore they are provided under Order 43 Rule 1. So therefore, it is a categorized distinction between the two. So therefore, to entertain a second appeal against an order would basically go against the principles of section 100 read with conjointly read with 43 Rule 1, because separate orders are provided for. That is one part. The second is that the proceedings not being a proceeding under the CPC. You see, the statutory appeal which is provided for, let us say that in a given case, what can I think of? Let us say this, what you call the earlier GMDA rules. If the permissions, etc., were not in accordance or somebody had a claim, district judge was the appellate authority. So against that order, we can't enter in a second appeal just because this district judge is there. You see, what happens is that a statute creates an appellate authority, like for example, the Education Tribunal in Assam. It's a latest requirement, which says that the district judge shall hear appeal from an education tribunal. And there are about 16, 17 acts, I will forget the names of those acts, where the district judge has been made or a sessions court has been made an appellate authority. Those are not specifically the issues which are under the CPC or CRPC. That is one part. The second part is see this. The High Court rules, I'll just tell it instead of passing on the book to you. You see, insofar as the certain acts are concerned, the High Court has the jurisdiction, for example, under the testamentary succession. The High Court in its rules has encompassed the appeal as provided for under the Succession Act, where it says under 299 the jurisdiction is of the High Court, and therefore it's a prescribed jurisdiction which we are exercising. This is one part. The second part, I'll show you something more. Because wherever statutory appeals are provided, for example, workman compensation, the Act says appeal to the High Court, and therefore High Court has framed a rule under which the compensation cases under Workmen's Compensation Act are entertained. This is one part, page 400. Yes, 316. Yes. You see, this is a provision relating to superintending jurisdiction of this court. Correct?
My lord.
Superintending jurisdiction. In the next page, 397, you will find the superintending jurisdiction extends to labor court.
Yes, my lord.
Correct? But not assistant labor commissioner. If it's a labor court, because labor court has judicial officers sitting there.
My lord.
Correct. So only those you'll find here. Now, surprisingly, you will also find that this workman's, what you call this assistant labor commissioner is not also within the superintending jurisdiction of this court. Therefore, anything wrong there, 227 is excluded because of this. And therefore, when the superintending jurisdiction is not there, not being a creature created under the CPC,
Yes,
to entertain a second appeal,
yes, my lord. Tribunals over which the High Court has the power of superintendence under Article 227 of the Constitution of India, irrespective of their nomenclature, which may from time to time be included in the schedule. Yeah, in this schedule, my lord.
assistant labor
court
commissioner is not there.
Yes, labor court is there.
Labor court is there because there is a judicial officer presiding over that.
Officers are sitting over there. Industrial tribunal,
There also judicial offices there. IMDT earlier judicial officers were there.
yes, ma'am.
So therefore, we have some control over that. That because since the judicial officers are there, so
My
therefore,
lord,
to
then may I request your lordship that as your lordship has already pointed out, because here in section 100 of the CPC, from every decree passed in appeal by any court, every decree, I will.
but there will be no
enunciate-
decree. There will be
Yes.
no decree in a payment of wages act. But I have seen in few cases.
Yes, but the order which is passed, the judgment which is passed, either in refusal or in admission by the district judge, itself amounts to a decree.
No, you are presuming it, but it is not. Because a decree, you see, for example, let us say, a very clean example, Arbitration Act.
My lord.
It says that the orders would be executable as a decree. And therefore, those decrees are executed by the district judge.
True.
Correct. There is a second example of a deemed decree, which is that, what you call, there is a Land Acquisition Act, 54 amounts to a decree. And therefore, in Land Acquisition Act also, the decree is being executed by the, if it proceeds under section 18, then the decree is under 54, a civil
By the
decree.
district judge.
So therefore, these are deemed decrees which are provided for in the special acts and thereafter taken up. So
My lord, if something is not mentioned in this schedule,
you can't assume jurisdiction because appeal is a creature of statute. There is a judgment of Supreme Court very clearly spelling out that the decree is so the appeal is a creature of statute, and that is why the residuary, what you call, provisions are being used for filing of the to challenge under the writ petitions. You see, when you see L. Chandra Kumar,
yes,
very clearly stated. Therefore, what the court has done that it's created a what you call appeal is not provided for, and therefore under Article 142, the Supreme Court says that the division bench appeal will lie in the division bench. So you see, jurisdiction has been conferred by the Supreme Court in exercise of power under 142 in L. Chandra Kumar's case. So therefore, the jurisdiction has to be explicit. Therefore, I will not entertain this as a second appeal.
My lord, in that case, I will pray before your lordship to convert into a writ or allow me to file it. That
So
is-
we'll permit you to withdraw it and we'll give you back your wakalatnama. We'll permit you to file it. That liberty will give you. Instead of because in appeal, it has to be a substantial question of law, grounds, and certificate, which is not a requirement under that
under that.
that act.
Thank you.
But Mr. Isatar Lanet, counsel for the appellant. The appellant has filed this appeal under section 100 CPC against the judgment dated 25/7/2023 passed by the learned District Judge Kamrup Metropolitan Guwahati in money appeal number 2 of 2021. First of the said appeal was entertained against the orders dated 18/2/2021 and 17/4/2021 passed by the Assistant Labour Commissioner come authority. Is authority or competent authority? What is the language?
Authority, my lord.
Authority. Under Payment of Wages Act. Full stop. The court is of the prima facie opinion that a second appeal would be maintainable only against a decree, and it is apparent from the provisions of section 15 read with section (26). No, not 26. (20) within bracket 6 of the Payment of Wages Act, that the enforcement of the award is ordered through realization of fines. The second appellate jurisdiction to this court is not conferred under the Payment of Wages Act, 1936. Whereas the Act provides for appeal before the appeal against the order of the Assistant Labour Commissioner before the jurisdictional district judge under section 17 within bracket 1 of the Payment of Wages Act, 1936. Next paragraph, therefore, comma, in the opinion of the court, comma, the appellate order passed by the learned district judge under the Payments of Wages Act, 1936, may be subject to revisional jurisdiction of this court. But second appeal under section 100 of the CPC would not be entertainable. So, Just before that, you also write, Mr. You are appearing in the matter.
Response number 1, caveat.
You file a caveat.
Yes.
But also ask Mr. R.C. Paul, counsel for the respondent number 1.
Yes.
Government is also there.
Yes, my lord. Response number 2.
Mr. K.K. Bhattacharya, government advocate appearing for respondent number 2. Next paragraph. Consequently, this second appeal is closed, however, with liberty to the appellant to challenge the order impugned in this appeal in such appropriate manner as the petitioner may be so advised. Full stop. In order to facilitate the appellant to do the needful, the court is inclined to direct the registry to return to the learned counsel for the appellant a copy of, the Vakalatma in original by retaining a photocopy of the first page and the last page on record for the record. Full stop. As the original copy is also there of this order, as well as the copy of the original
Annexure 3 and
order in appeal. Which one?
Impugn order, my lord, is annexure 39, annexure 6, page 39 to 43.
No, this is not the original one.
Impugn order,
No, this is not the original order.
original.
This is
order,
only a photocopy.
Yes, and the labor code, annexure 3 and annexure 4.
No, this is only a photocopy. Photocopy you need not give it, we did not return it to you. Because I am not holding the original one.
That original.
Oh, acha. The order of the district judge in original is here. Oh, okay. We also the registries. No, that's the first is that Bakaldama. And moreover, the registry shall also return the original certified copy of the order of Learned District Judge, Kanpur Metro, Guwahati in Money Appeal number 2 of 2021. As we find that the photocopy thereof is already annexed to this memo of appeal as annexure 6. Full stop. As the next paragraph, as the court has also not entertained the second appeal on merit, as the second appeal on the ground that appeal would not be maintainable, the registry shall also return back the court fees which has been paid by the appellant in form of court fee stamps with liberty to do the needful as the appellant may be so advised. Full stop. I'm saying so because even court fees can be returned to the collector. There is a provision for returning it.
Yes, my lord, that is 6,300 something like
No, I don't know, but there will be some deduction and you can still refund it. That's what I read earlier. I don't know now.
that.
So, stop with the aforesaid observations and liberty to approach the appropriate forum in appropriate jurisdiction. This appeal stands closed. Caveat discharged.
I
I also disposed of. Okay.
Right.
29.
You know, Mr. Satar, your smile, I'm just responding to that smile. You remember a few days back, there was a very viral statement of this bench being circulated that CPC makes a man slow. You've seen that? It was in wide circulation. It was in wide circulation, the statement of this bench. So I'm just smiling because of that. Yes, Ms. Roy. Just a moment. Give me 2 minutes. Please explain your substantial question of law number 1.
Right rate of position, cancellation of sale and permanent injunction.
You are the defendant. You are the plaintiff.
Using three of KP part number 9 of doc number 344 390.
Just a moment. You are the defendant. You are the plaintiff. Your suit was dismissed. And second appeal was also dismissed.
First title appeal was also dismissed.
Title appeal was?
So dismissed.
Dismissed. That's what I'm saying. Now, where is the plaint?
Is 5 minutes. And 2 1. Para number 6 of Para number 3, that the plaintiff inherited the said land of 3 acres by purchase from her mother and is enjoying the possession. By right of purchase, the name of plaintiff's mother in the year 1994 and after death of her mother in the year 1999, her name is mutated by right of inheritance. Plaintiff's predecessors purchased the suit land by registered sale. The suit land is comprising of 3 acres under doc number 344, 393, 397, and 387. There are 4 docs. And para number 6, my lord, I stated the plaintiff never sold the land to the defendant and she never executed any sale deed in favor of the defendant. The plaintiff.
You are reading where?
Paragraph number 6, my lord, of the
Page?
Page 6, my lord.
6.
Thank you, my lord. The plaintiff-
Yes, yes.
Plaintiff never sold the land to the defendant and she never executed any sale deed in favor of the defendant. The plaintiff, through his son, inquired and came to know about the sale deed and on at least 28/6/2014, he obtained a certified copy of the sale deed number from the sub-registry office, but the plaintiff never executed the said sale deed in favor of the defendant. The said sale deed holds illegal and can never be a valid one. From the certified copy of the sale deed, it is clear that the plaintiff never executed the sale deed, as in the sale deed, the plaintiff's husband name and address are not correctly stated. Moreover, the land in possession of the plaintiff is under doc number 344, 393, 397, and 387. But in the sale deed of the defendant, there is no mention of doc number 397. The two discrepancy in the plaintiff's husband name is not properly mentioned, and I purchased the suit, this is a purchase the suit land, it's registered sale comprising 4 ducts. But in the sale deed in disputed, there is only 3 ducts now. And in reply to it, the defendant in the written statement, page number 15, Miller, there is no specific denial, Miller. That the para number 8, that the averment made in para number 6 and 7 of the plaint is portion and blatant lie, transferring it in a never created fraudulent sale deed of the suit land in pollution with Ajit Rahman and Kapil Kachari, just to fulfill his wrongful gain. Therefore, the plaintiff is out to speak with thereof. There is no denial that the plaintiff never purchased the suit land in court. And the trial court finding in this respect, Miller, page number 30, Miller.
Page
Page 30, trial court finding,
30.
trial court finding, para 5, Miller.
Just a moment.
PW1 and PW2 depose the sale deed is forced as in sale deed number 67 of 2004. The name of plaintiff's husband is not correct and doc number 397 is not mentioned. It is to be stated that in sale deed, the name of plaintiff's husband is given as Mulong Sheikh, but Mulong Sheikh is the father of the plaintiff. The entry of plaintiff's name in the Jamabandi is as a daughter of Mulong Sheikh, and the defendant is claiming the draft of sale permission and sale deed is prepared by one Savin Kachari, and it is due to oversight of the scribe writer that mistakenly he has written Mulong Sheikh as husband of the plaintiff, and defendant who came to know of such mistake only in the year 2009. But no correction was made in law, even after knowledge of the defendant. It is pertinent to mention that plaintiff and defendant known to each other from earlier. The defendant was father in suit, but even before purchasing suit land, as the defendant possessed own land adjacent to the western boundary of the suit. As obviously plaintiff and defendant were well known to each other. It is also not that defendant has purchased the suit land giving some other name not relating to plaintiff. Defendant clearly stated that he has purchased the suit land from plaintiff. In record of that, the name of plaintiff is also mutated as daughter of Mulong Sheikh. Further contention is that doc number 397 is not mentioned in sale deed. In schedule of exhibit 3, sale deed, it is written that land measuring 2 bigger out of total land, 10 bigger of 4 ledge of Kepi Patta number 90 of doc number so and so is the purchase land. In schedule of exhibit 4, we find that the purchase land measuring 3 bigger of Kepi Patta number 90 of doc number 344, 393 and 387 of village Nakuchi under Moja so and so. It is the case of the plaintiff, and plaintiff has to show the area or portion of the suit land falls in doc number 397. As per certificate of Jamamandi total land with doc number so and so contains 5 bigger 1 cutter 10 ledger, and total land of doc number so and so contains 7 bigger 3 cutter 7 ledger of land. Now we are saying that in the sale deed defendant did not mention 4 that is not enough, as in 4 the total then covers 7 bigger 3 cutter 7 ledger, and hence the plaintiff is to specific regarding the area of land covered by Shagamathi. It is a joint particular. There is no partition made to me. And my specific case is that my predecessor purchased the full land by registered sale deed, and the land measuring 3 acre compressed in 4 ducts. And it is known to the defendant, and there is no specific denial in the written statement. But the court says that the plaintiff has to prove how the measurement of the land, that in each measurement of the land is and both the trial court and appellate court is finding that that I failed to prove that sale deed was fraudulently made. But that is
You see, I'm not being able to follow you. Number one, you say that the land was a joint pata land. Now, come to this plaint at page 5. You say the land measuring 3 biga is purchased by the plaintiff's mother, late so and so, to 30 to 33 years ago from so and so. Where is the joint patta has come in?
Below the total land in patta number 90 is 10 biga something.
No, we are not concerned with that.
Told me that there is an issue in this regard, my lord, whether it is
You see, what is your case? Your case is confined to 3 biga of land. And that 3 biga of land you say is under 4 dag. And therefore you say that the entire land was purchased by you from your by your mother from the Patadar Bhadar Chandra Bhattacharya. Now, how does the second person joint patta, how has it been created? And this you see, you are the plaintiff. You did not implement this joint patadar as a defendant in the suit. No. You see that those issues are, you leave aside the issue for the time being. Can an issue be decided in the absence of parties? So you see, if you are saying that there was a joint patadar, and now now what you are doing is, essentially you are waiving your right in favor of a third party. You claim that your mother purchased that land, and now you say that there is a co-patadar in your land, which means that you are relinquishing one part of the share of that land to somebody third party. No, otherwise, why will I admit that there is a joint patadar? Joint patadar must be having a share in the land. I don't envisage a situation where some joint patadar comes into the land without a share in the land.
Whether the suit is bad for non-gender of necessary, but that was discussed, my lord. Issue number 3, my lord.
Those things don't take us anywhere. Come to page 14, I'll tell you why. It is the plea of the defendants, which says that there are as many as 27 patadars who are possessing entire suit land consisting of 10 biga. But why would we like to inquire about this 10 biga? It would be just like a proposition in a cross-examination that, okay, what is the boundary of your land? He says that, Miss, in my west, in my north is Miss S. Roy. So it's a definite boundary. You see, we know that this is the suit land. Now in the north, the boundary is your name comes in. Then the question I asked in the cross-examination, who is to your north? And then you say Mr. Mitra. And then who is not to Mr. Mitra? Then you say Mr. Arnab Biswas is sitting here. Then to the north of that, he says Mr. Iqbal. And then Iqbal, after Iqbal, when you come to Mr. Alam and say, who is to your north? Mr. Alam stands up and says that, sir, that now that village has ended. Now I'm in a different revenue village. So you see, that inquiry leads us nowhere. You are confining yourself to the right title interest with regard to one of the part of the joint patta land, which is 3 biga, 3 katha. 3 biga. Now we'll have to find out that land only. In that land, there is no second patadar. Because you can't take benefit of your own fault. Supposing there is a second patadar, you admit that there is a second patadar, then you are the one who is who's executed that sale deed. And then you are denying execution of the sale deed. The witness comes before the court, exhibits your the original sale deed. One witness comes and says that my father was the scribe. He identified the signature, the thumb impression of the mother, and my father is expired. So he gives he proves the thumb impression. You, as a plaintiff, do not go to the court, seek thumb impression, identification through a forensic examination. How have you succeeded in showing anything? You are saying it is fraud. So forgery is something, the onus will be on you, the burden will be on you. And once you discharge that burden, then the owner shifts. So that thumb impression is yours, and that's something which is not denied. So why we should upset that finding in a second appeal? There is a discrepancy in sale. You can't take benefit of your own mistake. You see, let us assume the worst. You execute a sale deed. In the sale deed, you write not as ROI, but you spell it as RAI. That's the worst example I can give. I'm giving good in giving bad examples. So this you sign as RAI, and now you see that signature, your thumb impression, your execution is all everything otherwise admitted. Can the discrepancy of that name which you have yourself put can be a ground to cancel a sale deed? You can't take advantage of your own fault.
After vacation,
Even time after vacation. Okay. But then you'll have to remind us what we had delivered, because after vacation, I will not remember what transpired in the court. Correct. On the prayer made by Ms. S. Roy, counsel for the appellant, matter stands adjourned today. Sister unable to address the court just after ensuing winter vacation. And this is something, the example which I gave is something which has happened in court. It was in court of Musif number 2.
No idea.
Item 30,
With 30.
31.
30. Take up item number 31 first.
I have filed the Okada Sama for the respondents number 1, 2, and 3 matter today.
Well,
Item 13.
in fact, the claim, madam, there was an injunction order already there, madam, passed by the Honorable Court on November 10, 2023. Now, being the subsistence of the injunction order, madam, they have already violated the order. So we're going to file an violation application within a few days, madam. So let the matter come on Thursday, madam.
No, this before winter vacations, we are not taking up
First week of January.
those these matters. But why is this matter come today?
Service improvement.
So you have filed your wakalat number
Yes,
today
sir.
for this A, B, and C.
Yes, sir. Both cases.
Okay. Mr. Iqbal, counsel for the appellant, is present. Mr.
S. Azuri.
S. Hazarika, learned counsel, has entered appearance for substituted respondent numbers 1A, 1B, and 1C respectively by filing his vote. Today you filed.
Today.
It is submitted that the wakalatnama has been filed before the registry today. Stop the registry shall tag the said wakalatnama on record. Next para on the prayer made by the learned counsel for the appellant, matter stands adjourned today. List on give it in the first week. When do you want in the first week?
Any day, madam.
5th January 2024. In the second also substitution, second appeal of same order, past separate orders, but same order. Okay.
Deep privilege.
People.
32.
It is supposed to be listed for admission hearing, because the service has been already completed. Finally, see the order dated 8/6/2020.
Just a moment. What's this to? What stage of the This will go in admission stage.
Yes, my lord.
Okay. The counsel for the appellant and respondent number, you are especially respondent number 1 are present. The case is ready as regards. No, it will not come in admission. It will never come.
My lord, it was in admission stage, but due to last order, my lordship.
No, I don't know. That's why I asked you. 29/9/2023, Mr. R.C. Paul, counsel submits that he has been wrongly shown as so and so. Appellant is directed to take steps for service of notice upon respondent number 2 and 3. Office note of 13/12/2023 says that no steps was taken.
Actually, what happened, already steps has been already taken and already service has been returned, my lordship. 8/6/2020, kindly see the order dated 8/6/2022.
8/6/22.
2020. 8/6/2020.
Mr. S.B. Laskar and counsel for the appellant has referred to the office note dated 3/4, sorry. /03/04 6/2022, which indicates that notice has been served on the respondent numbers 1, 2, and 3. Postal. It is also shown that pursuant to the said office note, this court by order dated 8/6/2022 had accepted that the notice on respondent numbers 1, 2, and 3 have been duly served. Accordingly, the learned counsel for the appellant has submitted that there is notice was duly served. There was no requirement to take fresh steps pursuant to order dated 29/9/2023 for issuance of notice on respondent numbers 2 and 3. Just before that, right, Ms. S. Musahari, counsel for respondent number 1 is present. Next paragraph. As there is already a judicial order of 8/6/2022 accepting notice on respondent numbers 1, 2, and 3 to be duly served. The claim made by learned counsel for the appellant, issuance of fresh notice on the respondent numbers 2 and 3 is dispensed with. Next paragraph. The case is otherwise ready for regard service, less the matter in the admission column after ensuing winter vacation. Just tell me again. You say that notice was already issued.
Yes.
The appeal is made. Why then you'll come for admission again? You'll go for hearing then. Why admission? Notices. As the appeal has already been admitted, comment is the matter for hearing in its turn.
But it was I did not get any money, compensation, I did not receive any money due to pendency of this case. My lordship. So awarded, I didn't receive any compensation till date.
Oh, you have a very clean, what you call expressway for you, built for you. You enforce the order. There's an express highway built for you. If they are not deposited money in terms of the order of this court, and if there's no prohibition from enforcement, you go ahead and enforce the order.
Because of this pendency of the appeal, they are saying that they could not receive.
I don't know. I can only. You see, I have my limitations. Since I wear spectacles, I can only see what this spectacle permits.
Based on observation.
So I see a highway, you go into the highway. Correct? No, if the court doesn't proceed, then you come as you show before us that the court is not proceeding. On that you see, because I can't convert this high court to executing court. I'll not pass orders for execution here. Correct? Enforcement is a different chapter. If the court does not want to proceed, you bring that to the notice of this court, then we can see.
Yes.
Item 33.
Highly obliged.
Lordship, notice is not yet complete. Lordship, with Peru's office not dated 22/8/23.
My lord, I have a claim on behalf of the applicants, claimants, my lord. Here, my lord, an application was filed for releasing the deposited amount of award. My lord, the insurance company preferred appeal, my lord, and in the interim, by virtue of the order dated 13/12/21, my lord, this honorable court was pleased to stay the operation of the impugned judgment award, my lord.
Mr. Jain, we said there is a difficulty, you see. Once the court has issued a notice, then without service we can't proceed. There's already an order to take steps, and the service report is of 22/8/2023.
Respondent to.
Notice is served
On 6.
on
Six. Hours.
4,
So 4 in and.
4, 3 and 6. 4, 3 and 6 it has come back, served. So only 2 and 5 remains. You'll have to take steps, because in 2 it is written the address is not found.
My lord, it's a dispute in between the insurance company and the claimant. And
No,
the rest of
that I don't know. You see, I've got only 2 options. Number 1, either you proceed with 2 and 6 and serve notice, or you pray that this name may be struck off.
My lord, the name may be struck off.
Then it's
But
okay.
2 is the owner, Lordship. Our is gratuitous passenger, and that's why the day the.
No, you see, in this I can't apply my mind.
Like,
Correct. If it is his prayer, we allow it. But I've got 2 options. If there's a party, notice has to be served. If he wants to delete a party, is welcome. But I won't apply my mind here.
But
If
it
I
will be
start
at
applying-
his own risk, Lordship. That-
Definitely at his own risk. It is observed from the heard Mr. B.K. Jain, counsel for the applicant, and Mr. R.D. Mazumdar, learned counsel for the opposite party number 1.
Yes, Lordship.
Huh?
Yes, Lordship.
As per the office note dated 22/8/2023, notice is duly served on respondent number 2, 3, 4 and 6. So therefore, And however, comma, notice has not been served on respondent numbers 2 on the ground that two, as per office or as per process server's remark, address is not found, inverted commas. And service report on respondent number 5 is not yet received. Next, the learned counsel for the applicant submits that the respondent numbers 2 and 5 are not necessary parties for the purpose of adjudication of this application, and he prays that their names be struck off. So the prayer is allowed. The names of
The respondent 6 has not yet been received. Office noted dated is for office noted.
no,
Respondent
I think what I am reading is duly served.
So 6 is served. Office note
Duly served.
22/8/20.
Prayer is allowed. The names of respondent numbers 2 and 5 stand struck off on the prayer made by learned counsel for the appellant, which shall be at the own risk of the appellant. Sorry, applicant. Poster. Yes, now please tell us.
Hello. In terms of order dated 13/12/21, this honorable court must please to stay the operation and execution of the Bakijai proceeding. The entire operation was stayed, my lord, subject to deposit of 70% of the award. Subject to deposit of 70% of the award within a period of 6 weeks. In pursuant to that order, my lord, the insurance company had deposited the award before the Registrar General of the High Court. Subsequently, my lord, we filed an application for releasing this deposited amount of award. Against this petition, my lord, the insurance company, my lord, has filed an affidavit in reply. Affidavit in objection, they have filed an objection, my lord, objection on affidavit, and wherein they have basically they have pleaded that the disease was a gratuitous passenger at the material time of accident, and second point was that he was not hold the driver, the offending vehicle, the driver of the offending vehicle was not holding a valid driving license. These are the two grounds they have raised. However, my lord, on perusal of the judgment and award matter, it is crystal clear that the disease was traveling in the offending vehicle in the capacity of air paid owner of the goods that is eligible for pending the same at the relevant time of accident, as evident by the material evidence adduced by PW1, PW2, PW3, along with DW1, that is Bajaj, DW1, that is owner of the vehicle, coupled with judgment and award. So, my lord, when if we assume that there is a breach of policy condition, so even it is assumed or admitted that there is a breach of policy conditions by the insured, even in that eventuality, my lord, it would be equivalent if the insurance company pays the amount of compensation which is deposited before the Registrar General to the applicant claim and recovers it from the insured on the principle of pay and
Recovery, unfortunately, has been taken away by the amendment to the 1988 Act.
And moreover, Lordship, he has struck off respondent number 2. He is the owner of the vehicle. So he has struck off from where are we going to? And recovery is also taken away by the amendment.
In the memo of appeal, he is the party, my lord. In the memo of appeal, he is a party, my lord. Insurance company has been directed to deposit 70%. It is conditional for staying the operation of execution of judgment and award. They have deposited, my lord. And the honorable court was of the view that after deposit of that award, we have to file a necessary application for withdrawal of the award. Accordingly, we have filed, my lord. And now they have filed an objection on the grounds that he was traveling with a gratuitous passenger and driving license. These are, however, my lord, in the insurance company deliberately failed to adduce any evidence before the trial court. They have no evidence before the trial court. So, my lord, on the doctrine of pay recover, if the liability
Doctrine of pay and recovery, you see, today when I am passing an order, the Act has been amended. And it doesn't give retrospective effect to the pending cases. But you have not taken steps in appeal.
You have taken the.
No.
So Lordship will say office note dated 22/8/23 of the appeal Lordship, LCR received. AD of respondent 3, 5, 6 and 7 not received back. R4 served Lordship.
Order dated
Office note dated 22/8/23 Lordship.
22/8/23.
Yes, in MSC appeal 336 of 21.
Is this for 8/23? Now you have to take first steps. Those-
After that Lordship, it is now Lordship. We can take fresh steps and because they are necessary Lordship. And in fact, 7 is insurance company, the.
Correct, in that application. I have to rise, there's a call. In fact, you see, for this interlocutory application, the owner is not a necessary party. About the pay, so far as degrees of the money is concerned, there is only, you are the necessary party. And in this appeal, we are not striking out those people.
So we cannot
So-
strike out Lordship, take fresh,
you
because
have
it
to
has
take
come
steps.
now Lordship, so we will take fresh.
But
steps.
yes, why it should not be released? If he's if the evidence shows that he is a passenger,
No Lordship, his father and he, 2%, but the policy contained that only 1 person can move and it is evidence. Ramavatar was also traveling in the vehicle and he was in the cabin. So only 1 person will be covered Lordship, he was in the body of the year and that's why he fell down from the.
where is that?
Lordship, that is in the evidence. Lordship.
No, my lord, there is no evidence, my lord.
No, no, not our evidence.
Please, please,
Lordship, there-
don't interject. I am asking a question, let her respond.
It is there.
If you want to speak for her, you'll have to come here and then speak for her. Correct?
It is,
Yes,
it is from their evidence only we are.
shows that.
Lordship, the LCR has come. Lordship can in fact take up the hearing. I have to go to the
So
LCR.
today, there's a call has come, I have to go. There's a,
Appeal, we will take fresh steps, Lordship.
we will take it up on, in the reopening. Due to positive time, the matter could not be taken up today. This will be an IA, huh? List on 4/1/2024. In the appeal, you write. Just Mr. BKCN here and RD Mazumdar for respondent 1, and then in appeal you write. RD Mazumdar, Mrs. RD Mazumdar, counsel for the appellant, and Mr. BK Jain, General Counsel for respondent numbers 1 and 2. As per the office note dated 22/8/2023, AD cards of respondent numbers 3, 5, 6 and 7 is yet to be received. So the appellant shall take steps. First steps for service of notice on these said respondents by registered post with AD. The notice is made returnable on so and so. Postal receipt, track report. Then you also say in the front, in the above you write as per office note dated 30/5/2023, AD card in respect of respondent number 4 has been received back. Now, what about this 1 and 2 is there?
They are claimants.
They are claimant 3, 5, 6 and 7, we have already said. Okay. Nobody's left out?
No.
Okay, list on so awaiting service. Take fresh steps.
Yes, Lord.
This IA we are fixing out in January. Other matters will be all rolled over. In any matter where the stay is to be extended, please tell. Otherwise, the matters will all be rolled over. Mr. Gaurav, good to see you again. Sir.
Much obliged.
21st, it can't be taken up. This is a hearing matter. No, I understand, but we will not be able to take up. In the month of January, you please suggest a date, we'll fix it on that day. But you'll again not be there. No, April, we can't say that. We just say list. We just say list after 4 weeks. You ask Mr. Laskar to remind me of your statement. Will adjourn because long adjournment can't be given.
Lordship,
Okay.
item number 48, my lord.
Just wait. I'm sorry.
Oh,
we'll
yes,
wait
sir,
later.
I understand. 44, let it be fixed on after vacation on 8th of January or 9th of January.
Not good.
44.
The positive time matter could not be taken up today. Mr. PJ Datta, Senior Counsel.
Be that.
B. Datta, Senior Counsel for the appellant submits that there's some urgency in the matter. List on.
Eight.
Okay. Other matters will be loaded over.
Lordship, item number.
Lordship.
You make a mention because we find it very difficult to adjust. Because you see, the difficulty is that we can't pick and choose one case and the other we don't pass an order. So make a mention after that, it will be rolled over. Because I am passing orders in Mr. Datta's matter because he made a mention at 10:30 in the morning. So that's why.